as to the pronunciation of the names, how does this sound? Mr. Warner, Mr. Burrell, Mr. Corey, and Ms. Conway. Any objections?
Barilli, Your Honor.
I'm sorry?
Barilli, Your Honor.
Barilli, excellent, thank you. I strive to pronounce names correctly.
Your Honor, all participants are present, and I will now call the case.
Very well.
The Court of the District of Buffalo-Niagara is now in session. Honorable Judge Glenn Murray presiding.
Excellent. Well, everybody looks ready to go. We may proceed. I suppose we will proceed with some administrative matters. Who will begin?
The state will begin, Your Honor, if that's all right with you. But first, may we make appearances before the court?
Yes.
Good morning, Your Honor. My name is Caitlin Conway. I'm joined today by my co-counsel, Omar Corey.
Good morning, Your Honor.
Morning.
And we represent the people of Buffalo-Niagara in today's case.
Excellent. And for the defense?
Yes, Your Honor. Good morning. My name is Nathaniel Warner, and I'm here with Mr. Nicholas Barilli.
Good morning, Your Honor.
Good morning. You may proceed with any administrative matters.
Yes, Your Honor, the state does have some housekeeping matters. First, we'd like to ask your preferences in this digital courtroom for sharing our screens and showing evidence to opposing counsel and the witness. May we do so and announce for the record that we're doing so, or would you like us to ask permission first?
You may do so without asking permission.
And after evidence is admitted, should we assume that it's published to the jury, or should we ask to publish after admitting?
You may assume without asking.
Can we assume that all witnesses are constructively sequestered, barring a party representative?
You may.
And can we assume that all objection arguments are heard outside of the earshot of the jury?
You may.
Your Honor, we have no other housekeeping matters.
Very well. Any housekeeping matters for the defense?
No, Your Honor, just to note that for 615 sequestration purposes, Ms. LaHood will be present throughout trial. She's the defendant in this case.
Very well.
And that's all from us. We're ready to move to substantive matters.
Very well. You
Your
may
Honor,
proceed.
yes, Your Honor, the state does have a motion today. We've already talked it over with opposing counsel. Our motion today is asking that all evidence about one of our witnesses, William Scarlett, all evidence of his prior status as a drug user, a drug addict, or a drug dealer be excluded from all evidence in today's trial. Now, William Scarlett is here today testifying as part of a plea deal, and we have no objection to opposing counsel diving in as to the conviction that led to that plea deal, and that is a possession of a controlled substance charge. So we have no issue with opposing counsel going into that content, but we do take issue with any evidence of his addiction, drug use, or drug dealing. Opposing counsel has said they have no plans to go into this kind of content, so we just wanted to bring it to Your Honor's attention and ask that we be able to re-raise our objection if they do go into that area.
One moment. All right, well, I am not as conversant with the background as you are. Let me see if I understand this correctly. This is a stipulation that the defense may inquire into a conviction which was incidental to a plea deal. In other words, testimony in exchange for leniency. However, they are not allowed to inquire as to any history of addiction, drug use, or drug dealing. Did I state that correctly?
Yes, Your Honor.
All right.
Your Honor, may I just be heard briefly on that?
Yes.
That's not quite the stipulation that I believe we agreed to. We don't anticipate going into prior drug use or drug addiction. The conviction is for possession of cocaine. The only time we would get into past conduct, past dealing would be for impeachment. If, for example, the witness denies having that conviction or denies ever dealing drugs in the past. So just for that limited purpose for impeachment, we might need to get into the underlying circumstances. But unless we need to impeach, we don't anticipate doing that. So outside of that narrow scenario, we agree that we don't plan to get into any of those facts.
All right, well, we may have to cross that bridge when we come to it, but I want no misunderstandings as to the stipulation. I interpret what you just said as follows. You may get into the drug history, if the prosecution opens the door. And on the other hand, one example might be and another way that it could be delved into would be if the witness were to deny previous drug dealing. However, it would seem to me that the scope of the stipulation would restrain you from asking the question about prior drug dealing. Ms. Conway, do you think that the defense is restrained from asking questions about prior drug dealing?
Your Honor, we did agree that the defense could ask about prior drug dealing or not prior drug dealing, but prior drug use if the witness denied having that conviction, that possession conviction. But we do not believe that talking about the conviction should open the door generally to discussion about drug use. Only if the witness lies and for impeachment purposes can that information be delved in. And I still think it can be more prejudicial than probative if opposing counsel does go into that. So we may still have an objection argument even if they do.
All right, well, it seems to me that the only tricky part is going to be if the witness denies the previous conviction, and neither party anticipates that the witness will deny the previous conviction. And if he admits the previous conviction, then the stipulation would bar any further inquiry as to addiction, drug use, or prior addiction, drug use, or dealing. Is that fair to say?
Yes, Your Honor.
All right,
is.
so this may become academic, and it would be nice if as long as the witness is well prepared, then we can avoid complicating that stipulation any further. Very well. Unless there's anything further that needs to be said about that stipulation, are there any other stipulations or housekeeping matters or motions in limine?
Not from the state, Your Honor.
As to the defense?
Yes, Your Honor. The defense does have one motion. We move under Rule 404B to preclude any mention of an alleged poisoning incident involving Marianne Mariansky in 2010. We think that evidence is not only inadmissible, it's deeply prejudicial, and we don't want it coming out in front of the jury. Just by way of background for the court, Miss Mariansky is the girlfriend of our client, Miss LaHood. We also expect her to testify in defense today. 11 years ago, there was an allegation made that Miss Mariansky acted to sabotage a competitor of Miss LaHood's at an archery competition, and that she took the fall for Miss LaHood when the sabotage scheme was exposed. We think that any mention of that incident is inadmissible under 404B because it creates a propensity issue. The state would be using that evidence to argue that because Miss Mariansky took the fall previously, she's more likely to have taken the fall in this case. And that's why it runs afoul of 404B.
And what does the prosecution say about that?
Yes, Your Honor, may I respond?
Yes.
Your Honor, we would object in large part because a fundamental element of the defense's case is that Marianne Mariansky had a personal vendetta against the National Archery Association stemming from this incident in 2010. It is the defense's story that because of this vendetta, she chose allegedly to shoot at her half-brother, Mr. William Scarlett, as part of an insurance for the defendant LaHood to remove the NAA from her will. And because we are in the spirit of providing the jury with a picture of evidentiary fullness, we find that the jury is entitled to a full understanding of the events of 2010 so they can make a reasonable conclusion as to the reasonableness, or as to the veracity, I should say, of the story that Ms. Mariansky indeed had a vendetta against NAA, and that it was actionable on it enough such that she would shoot at her half-brother with a potential to kill him.
May I respond, Your Honor?
You may.
None of that requires the state to elicit testimony regarding the specific allegation that she somehow engaged in sabotage or otherwise was accused of taking the fall for Ms. LaHood. The state can elicit testimony that she has animus towards the NAA. They can talk about the fact that she's not a fan of them, but they're not required to get into the underlying facts and circumstances. And if they do, there will be a substantial danger that the jury will use propensity reasoning. They'll say because she took the fall then, or was accused of taking the fall then, she's more likely to have taken the fall in the case at bar.
All right. I'm going to reserve decision on that motion in limine. I will say that the evidence seems relevant, and how far the inquiry may proceed would depend upon the responses of the witness. With that, any other motions in limine or housekeeping matters?
No, Your Honor, defense is ready for opening statements.
Very well, we may proceed. We will proceed to opening statements.
May I
Who will
proceed, Your
give
Honor?
who will give the first opening statement?
I will, Your Honor, on behalf of the prosecution.
Very well. You may proceed.
May it please the court, opposing counsel, members of the jury. The defendant was tying off loose ends. It's August 6, 2020. Guy Gisborne is at the defendant's estate. He's going to meet up with his lover, William Red Scarlett. Now, they meet up. They decide to go for a walk in the woods. It's dark outside. They think they're alone. They're about to share a moment. Suddenly, Guy Gisborne gets shot in the back with an arrow. Mr. Scarlett, his lover, looks up to see that arrow protruding from the bloodied body of his lover, and he books it. Now, whether it's through fate or through luck, Mr. Scarlett falls. And as he's falling, another arrow whizzes right past his head, barely missing him. Had Mr. Scarlett not fallen, he would have been hit. Members of the jury, we're here today because of the defendant's actions. The defendant, Robin LaHood, shot that arrow from that bow that killed Mr. Gisborne. We're here today because the defendant tried to kill the only witness. We're here today because the defendant was tying off loose ends. Now, you'll learn that the defendant was in a sham marriage with her victim, Guy Gisborne. You see, the defendant needed to marry a man in order for her to get her inheritance. So she struck up a deal with Mr. Gisborne. And in exchange for Mr. Gisborne marrying her, she would pay him $5 million after their divorce. Now, that sounds like a great deal, except for you'll also learn that come time for that divorce, the defendant didn't want to pay Mr. Gisborne. Mr. Gisborne, well, he was furious. He had just been slighted. He had spent the last 2 years of his life pretending to be straight, all for a payout that was never coming. So he devised a plan with his lover, William Scarlett, to take back that money. That plan fell through. The defendant found out about it. And nearly a month after that plan fell through, months after the defendant refused to pay Mr. Gisborne, he paid with his life. Mr. Scarlett almost paid with his. Now, because of the defendant's actions, she's facing 2 charges. A charge in the second-degree murder of Guy Gisborne, and another charge in the attempted second-degree murder of William Scarlett. Now, as the prosecution, we bear the burden of proof. We must prove beyond a reasonable doubt that the defendant intended to kill Mr. Gisborne and did so without legal justification. We must also prove beyond a reasonable doubt that the defendant intended to kill Mr. Scarlett and attempted to do so on the night of August 6, 2020. And to prove that burden, we will call two witnesses. Members of the jury, today you'll hear from the victim in this case, William Scarlett. You'll hear how he almost lost his life that night. You'll hear how he knew that the defendant and Mr. Gisborne were in this sham marriage, and when time came for the defendant to pay Mr. Gisborne, well, she figured it'd be easier to kill him, and she figured it'd be easier to kill the only witness. You'll learn that the defendant was tying off loose ends. And you'll also learn from Detective Newt Figton. And Detective Figton, well, he'll walk us through his investigation. He'll show us how all of the questions he asked, all of the evidence he gathered led him straight to the defendant's doorstep. And you'll also learn that when the defendant was asked those questions, well, she dodged questions, she changed her answers, she hid evidence from police, she even destroyed evidence. Members of the jury, we're here today because of a tale as old as time. Money and revenge. Money and revenge. You will learn that the defense's story, well, it's based on a mountain of lies. From changing stories of murder, to hiding evidence from law enforcement, to even scapegoating the blame away. From this litany of lies, a truth will emerge, that the simplest explanation is the one most likely to be true, that the defendant intended to kill Mr. Gisborne and Mr. Scarlett, that the defendant was successful with one and almost with the other, that the defendant was tying off loose ends. That's why at the end of this trial, my co-counsel, Caitlin Conway, will come before you and ask you to find the defendant guilty on both charges. Thank you.
Opening from the defense. Your Honor, I believe you're muted.
You may proceed.
Thank you. And may it please the court. This is a case about two questions. Why and who? Now, when Mr. Corey was talking just now, I found myself nodding along to a lot of what he said. That's because, as you'll learn, there's a lot about this case that the prosecution and defense agree on. We agree that last August, Miss LaHood shot Guy Gisborne with an arrow. And we agree that someone fired a second arrow at the man he was with. But where we don't agree are on the answers Mr. Corey gave to two key questions. Why and who? Why did Miss LaHood shoot that first arrow? And who shot the second one? Because what you'll see is that the only loose ends in this case are the questions the state can't answer. You'll learn that the man Miss LaHood shot, Mr. Gisborne, he went into those woods for a reason. But it wasn't the romantic story the prosecution just told me. He went into those woods to kill his boyfriend. And when Miss LaHood found out about that plan, she did what anyone would. She tried to stop it. She fired that arrow at Mr. Gisborne because she believed it was the only way to stop him from killing his boyfriend. And that second arrow, you'll learn that Miss LaHood is just not the person who fired it. That the person who did is actually Miss LaHood's girlfriend, and that her girlfriend admits it was her. And those questions, why and who, They matter for the prosecution because they have the burden of proof. They've charged Ms. LaHood with murder and attempted murder. And to meet their burden, they have to prove every element of both of those charges beyond a reasonable doubt. They have to prove the answers to those two questions beyond a reasonable doubt. And look, I know this is a complicated case with a lot of facts and names and relationships. So I just want to take a moment to walk through exactly who the four people involved in this case are. The first two are Guy Gisborne and Robin LaHood. They're married, but they're both seeing other people. Mr. Gisborne's boyfriend is named William Scarlett, and Miss LaHood's girlfriend is named Marianne Mariansky. So now let's turn to the evidence you'll see today and walk through exactly how it will show the prosecution can't answer either question beyond a reasonable doubt. So why did Miss LaHood shoot that first arrow? Now that question matters because even though we agree Miss LaHood killed Mr. Gisborne, the prosecution is required to prove that she wasn't legally justified in doing so, that no reasonable person in her position would have believed that deadly force was necessary to stop Mr. Gisborne from harming someone else. But what you'll see is that's exactly what happened. You'll hear from Miss LaHood directly. She'll explain that on the evening of August 6th, she learned that Mr. Gisborne had a plan to kill his boyfriend, that he was planning to use an allergen, peanut oil, to do it, that he planned to take his boyfriend out into the woods, put him in a compromising position, and kill him with that allergen while the two of them were alone. And she'll explain that right after she learned about this plan, she saw Mr. Gisborne leading his boyfriend into those woods. So she grabbed a bow and arrow and ran after them. And she'll explain what was going through her mind. That when she saw Mr. Gisborne standing while his boyfriend was on the ground, watched him reach into his pocket and start to pull something out, she realized he was about to use that deadly allergen. And if she tried to call for help or shout out a warning or run over, she would be too late. She'll explain that she only had one option: to shoot. So that's what she did. And today you won't just have to take Miss LaHood's word for what happened. You'll learn that the police investigation confirmed that Mr. Gisborne had that deadly allergen in his hand when Miss LaHood shot him. So that's the answer to why Miss LaHood fired that first arrow. Now let's talk about who fired the second one. Because to meet their burden for the attempted murder charge, the prosecution has to prove beyond a reasonable doubt that it was Miss LaHood. But as you'll learn, that's just not what happened. Miss LaHood will explain that it was her girlfriend, Marianne Mariansky, who fired the second arrow. And when Miss Mariansky testifies, we expect she'll tell you why. That her relationship with Miss LaHood had problems. Miss LaHood had a lot of money, and Miss Mariansky felt like after years of waiting, she deserved a cut. So she didn't see that night as the tragedy as it was. She saw it as an opportunity. You'll see that that's why Miss Mariansky fired the second error, for money, so she could blackmail Miss LaHood. And I want to be clear, we aren't going to try and tell you that that was a good reason. It wasn't. We think Miss Mariansky's actions are indefensible, but you don't have to agree with or even like Miss Mariansky to see that her testimony is backed up by the evidence in this case. Because you'll see there's no eyewitness testimony that connects Miss LaHood to that second error. No forensic testing that connects Miss LaHood to that second error. That all the evidence that the prosecution does have is consistent with Miss Mariansky firing. You'll see the answer to that second question. Who shot the other arrow? It's Miss Mariansky, not Miss LaHood. At the end of trial, my co-counsel, Mr. Barilli, he'll talk with you again. He'll walk you through all the evidence you've seen and explain exactly how it is the state can't prove the answers to either of those questions, why and who, beyond a reasonable doubt. How they can't meet their burden. And he'll ask you to find Miss LaHood not guilty. Thank you.
Thank you. Very well. Prosecution may proceed.
Yes, Your Honor, the prosecution calls William Red Scarlett to the stand. May I proceed, Your Honor?
You may.
Good morning. Please state your name for the court.
Good morning. My name is William Scarlett.
Mr. Scarlett, let's begin by telling the jury why you're here today.
I'm here today under a plea agreement. In return for my testimony about the murder I witnessed, the government has agreed to give me a lesser sentence for the crimes that I've committed.
Do you understand that you're testifying under a waiver of immunity?
Yes, I do.
And do you also recognize that you're going to be given a reduced sentence as a result of your cooperation in court here today?
Yes, I do.
Mr. Scarlett, as part of that plea agreement, what crimes did you plead guilty to?
In July of 2020, I was arrested for criminal possession of a controlled substance. And then later that year, I was charged with conspiracy to murder Robin LaHood.
Yeah, Mr. Scarlett, I want to get to that in a bit, but first I want to talk about Guy Gisborne. Did you know Mr. Gisborne?
Yeah, of course.
And how did you know Mr. Gisborne?
We met years ago at a nightclub of all places. We were immediately attracted to each other, but at first things weren't that serious.
How did your relationship develop?
We went on a few dates, started to fall in love. We moved in together, we settled down. And one day he told me he was going to marry somebody else.
Who was this someone else?
Guy was going to marry Robin LaHood. She is this wealthy businesswoman here in Buffalo-Niagara. She owns her own company. And she told Guy that she would give him $5 million if they were to get married.
Objection, hearsay.
May I respond, Your Honor?
You may.
You know, one of the exceptions to the rule against hearsay is 8033, which is the then existing mental, physical, or emotional condition. One of the elements of the then existing mental, physical, or emotional condition is the statement of a plan. In this case, the witness had just articulated a plan that Mr. Gisborne was going to have with the defendant LaHood, that in exchange for marrying her, she would pay him $5 million.
May I be heard, Your Honor?
Briefly.
There's two layers of hearsay here. There's the first statement, the first layer, in which Miss LaHood tells Mr. Gisborne allegedly what her plan is. Now, that exception that Mr. Corey talked about, that would apply to the first layer of hearsay because it goes to the declarant's state of mind. The issue here is the second layer of hearsay. Mr. Gisborne relaying what he heard to the witness, Mr. Scarlett. That layer of hearsay is not captured by the 8033 exception because Mr. Gisborne is not the declarant in question.
The declarant will be testifying at this trial, correct?
My understanding, Your Honor, is that the declarant in this case, Mr. Gisborne, is deceased, so he will not be testifying.
Oh, okay. So it was Gisborne who said that the plan was for money.
And that statement itself was based on the hearsay statement of Ms. LaHood.
All right, I'm going to overrule the instruction. I will instruct the jury at the end of the case that this was admitted not for the truth of the matter. You may proceed.
Thank you, Your Honor. Mr. Scarlett, who is defendant LaHood?
She's this very wealthy businesswoman here in Buffalo-Niagara. Owns her own company, and her and Guy agreed to get married if she would pay him $5 million.
Do you know anything about defendant LaHood's archery skills?
Yes, she's a professional archer. She competed in the Olympics, I think in Athens.
Now, Mr. Scarlett, how did you react to this development of Mr. Gisborne going to marry defendant LaHood?
I mean, it was tough at first to find out that my boyfriend was going to marry somebody else. But that money, $5 million, that's no small amount. That was a life-changing amount of money. So we agreed to go along with it. Knowing now, I wish we hadn't.
What was your relationship like with the defendant?
It was never good. She never seemed to like me. She would be cold to me. She would act like I wasn't even there sometimes.
Mr. Scarlett, did defendant LaHood ever say anything to you that would otherwise indicate to you that she didn't like you?
I mean, all the time. She would call me names. She would call me a worm because she thought I was leeching off of Guy. She would insult my masculinity because one time I didn't want to have her, shoot an arrow or shoot an apple off the top of my head with an arrow.
Mr. Scarlett, I want to talk a bit more about this agreement that Mr. Gisborne and defendant LaHood had with each other. Could you tell us a bit more about that?
Yeah, they basically agreed to have a fake marriage. Robin's father had told her that she wouldn't get any part of his inheritance unless she married a man. And Guy was, I guess, the only man she could find. So the idea was for them to be married until her father passed away. And then at the end, after the divorce, Guy would get paid his money.
Was there ever an issue that arose from that agreement?
Well, yeah, the paying the money part. When they got divorced after Robin's father died, Robin, she just never paid up.
How did Mr. Gisborne react to this news?
He was upset. He was angry. He told me that we had to do something, that we needed to get revenge.
Did you help Mr. Gisborne out with his plan?
I did. Guy had asked me to find a hitman, someone to take out Robin LaHood, and I knew somebody, so I got him in touch with that person.
Mr. Scarlett, how did that plan turn out?
It didn't. The entire plan fell through. We sent the hitman to Robin's home, and he broke in, and when he did, he was shot, and he ended up in the hospital.
Did you ever visit Mr. Frierson in the hospital?
I visited him a couple of times. He did not look well. He looked like he was at death's door.
And Mr. Scarlett, during that second time you visited him in the hospital, what did Mr. Scarlett say to you? Excuse me, what did Mr. Frierson say to you?
He told me that he was sorry, but that he had told Robin our entire plan.
Objection.
Him to kill.
Hearsay, Your Honor.
May I respond, Your Honor?
You may.
Your Honor, one of the exceptions to the rule against hearsay would be when the declarant is unavailable. The declarant, in this case, Mr. Tucker Frierson, is unavailable because he is deceased. Now, there's a second element to that test, which is that statement that Mr. Frierson gave to Mr. Scarlett. Well, that was a statement that was made under belief of imminent death. As Mr. Scarlett had just testified, Mr. Frierson had indeed looked like he was on death's door. And in fact, he was on death's door because he had just been shot by a crossbow, and that wound turned septic. Furthermore, the defendant, Mr. Scarlett had testified that when he spoke to Mr. Frierson said that he apologized, that Mr. Frierson had actually lied to Mr. Scarlett and Mr. Gisborne, that he didn't tell defendant LaHood about the plan that they were responsible for. That would be a statement against interest under 804B4, if I'm not mistaken. So because of those two exceptions, the statement against interest and because of the statement made under belief of imminent death, this testimony is admissible.
May I be heard, Your Honor?
Briefly.
I'll address each of the exceptions in turn briefly. With regard to the first exception that was proffered, the statement under belief of imminent death under 804B2, that test specifically requires that the statement in question be about the cause or circumstances of the defendant's death. We just haven't heard that foundation. And I have a good faith belief that the statement that's going to be elicited was actually made after the break-in and after the declarant was shot by Ms. LaHood. It's a post hoc statement that doesn't go to the cause or circumstances of the death. With regard to the statement against interest, that requires that there be a proprietary or pecuniary interest, a financial or property interest that was shown, or some other kind of criminal or civil liability. That foundation has not been established, so neither of those exceptions would apply based on what's on the record.
May I respond briefly, Your Honor?
Yes.
Your Honor, this is directly as a result of the consequences of that break-in a month prior. As the witness had just testified, Mr. Frierson was shot in the stomach with a crossbow. It is because he was shot in the crossbow that he was in the hospital, and it was because he was shot in the stomach that wound turned septic. This is a direct causal connection between that event that caused that circumstance that happened in July of 2020 and when Mr. Scarlett visited Mr. Frierson in the hospital a month later. Furthermore, regarding the statement against interest, Your Honor, this exposes both Mr. Frierson, Mr. Gisborne, and Mr. Scarlett to criminal liability, that they testified, or that they would testify that indeed they did plan and orchestrate a plan, rather, to try to kill defendant LaHood, which is exposing them to criminal liability. It falls blatantly under both exceptions.
May I briefly respond, Your Honor?
No, I'm going to rule. I'm going to, I reject the dying declaration exception. I accept the declaration against penal interest. The question may proceed.
Yes, Your Honor. Mr. Scarlett, I'm going to re-ask my question. When you visited Mr. Frierson in the hospital that second time, what did he say to you?
He told me that he was sorry, but that he had told Robin everything. He had told Robin about our plan to have her killed.
Now, I want to switch gears a bit and talk about your relationship with Marianne Mariansky. Do you know Miss Mariansky?
Yeah, I do.
And how did you come to know Miss Mariansky?
Well, I actually met Marianne through Robin. While I was Guy's boyfriend on the side, Marianne was Robin's girlfriend on the side. And it turned out that we actually happened to be related to each other, and she's my half-sister.
Did you say half-sister?
Yes. I know it sounds weird, but she's my sister on my mother's side, and we only found out, through this whole ordeal.
And what was your relationship like with Miss Mariansky?
I mean, it was good. As good as it can be for two siblings who didn't know about each other for the first 30 plus years of their lives. We would often talk about our relationships and our problems, and it was nice knowing that I still had family left.
Do you know whether Miss Mariansky knew how to shoot a bow?
Yeah, I actually do. Robin had told me that she couldn't hit the broadside of a barn.
Now, Mr. Scarlett, there are a lot of names, a lot of characters in this case. Do you think you'd be able to make use of a diagram to just show everyone's relationship with each other?
Yeah, I could do that.
Your Honor, permission for this witness to make use of a demonstrative?
He may.
Mr. Scarlett, could you explain to the court who everyone is?
Of course, I'll start with myself. I am William Scarlett. Sometimes I go by my nickname Red. And since 2015, I had been dating Guy Gisborne. We moved in together, we were in a relationship together. around 2018. Guy said he was going to marry Robin LaHood, who also goes by RJ. And then Robin, throughout their marriage was also dating someone else, Marianne Mariansky, who was her lover, but also like her employee and like assistant, that sort of thing. And then finally, Marianne was my half sister. That's how we all knew each other.
Thank you for that, Mr. Scarlett. I want to turn our attention to the events of August 6, 2020. Do you recall the events of that day?
Yeah, I do.
And how did that evening begin?
Guy had invited me over to his place that night. This was after the divorce, but he was still living on Robin's property in the guest house.
And when you got to the guest house, what happened next?
Well, we had a talk. Guy said, he felt sorry about the way he had treated me the past couple of months. Things had been a little tense in our relationship, but he said that he still loved me. And he asked me to go on a walk in the woods.
And what happened next?
Well, we went on our walk, and I hadn't seen Guy in a bit at this point, and it was just the two of us. It was a romantic night out, and so we walked into the woods where we can be alone. And we went in the woods to do. You know what we were going to do in the woods,
I'm sorry, Mr. Scarlett. We need to be clear for the jury. What was going to happen in the woods?
Well, Guy and I were going into the woods to have sex where no one else could see us.
And what happened next?
Well, Guy was standing in front of me, and I was kneeling in front of him, and he went to undo his zipper, and then I heard this whizzing sound followed by a thud, and I heard Guy gasp, and I looked up, and I saw the arrow coming out of his chest.
What happened after that?
I ran. As soon as I saw what had happened to Guy, I was getting out of there because I didn't want to be next.
And while you were running, did you also get shot at?
No, but while I was running, I tripped, and just as I tripped, an arrow went flying right over my head too.
Now, after this, what happened then?
I got up and I ran as fast as I could, and I got out of there. I made it to the road, and eventually I hitchhiked my way back home, and I was just stunned. I couldn't believe what I had just seen. And then a day or two later, I went to the police.
Mr. Scarlett, who do you think shot you that night?
It was Robin LaHood.
And Mr. Scarlett, did you fear for your life that night?
I thought I was going to die that night. And if I hadn't tripped and fell, I would have.
Thank you, Your Honor. No further questions.
Very well.
Cross, Your Honor.
Cross may commence.
Yes, Your Honor. Good morning, Mr. Scarlett.
Good morning.
I want to start by talking to you about something that you mentioned a few moments ago on direct examination. Sir, you said that you have a deal with the state. Is that right?
That's right.
I want to ask you what you're getting for that deal and what the state's getting for that deal.
I'm getting a reduced sentence.
Sir, well, I'll ask you a question. I'm just giving you a heads up what we're going to talk about.
Oh, I'm sorry.
As part of the deal that you made with the state, you are required to testify for the state.
Yeah, I'm required to testify and tell you all what I saw that day.
That's your end of the bargain, right?
That's what they get. Yeah.
Let's talk about what you get, sir. You would agree that you have a criminal history.
I do.
You've pleaded guilty to multiple crimes.
I did.
You've pleaded guilty to drug possession.
Yes.
You've also pleaded guilty to a murder conspiracy.
Yes. Planned to have Robin killed.
And you haven't been sentenced yet for those crimes, have you?
No, not yet. But they told me the maximum sentence I can receive now is 9 years thanks to this deal.
Well, we're going to get into all that, sir, but I want a simple yes or no answer. You haven't been sentenced yet for those crimes, right?
I have not been sentenced.
That sentencing is going to happen after this trial takes place.
That's right.
You know that you're facing prison time.
Yes, I will be going to prison for the crimes I've committed.
What this deal changes is how long you're going to spend in prison.
Yes, they told me that the maximum sentence is going to be 9 years.
And before you made the deal, sir, you were looking at a maximum sentence of 25 years. Isn't that right?
Yes, for the conspiracy to commit murder.
That's a 16-year difference. Isn't that correct?
That's right.
Let's talk about how you made that deal, sir. Fair to say that you were the one who first reached out to the state?
Yes, I called the police first.
And you called the police because you wanted a lighter sentence.
Yes, I did.
You knew you weren't going to get a lighter sentence unless you told the state information that they wanted to hear.
Yeah, I knew that if they saw that I'd planned to have Robin killed, that I would have to tell them everything.
That's a yes to my question, sir. You knew you weren't going to get a lighter sentence unless you told the state what they wanted to hear.
No, that's not true. I'm sorry.
Well, sir, is it your testimony that you did not provide information to the state as part of your deal?
Oh, I provided information to the state, but I don't think it's what they wanted to hear. I don't think anyone wants to hear about a murder. I just told them what I had witnessed.
All right, Mr. Scarlett. Well, let's talk about what you told the state exactly. Your story is that you and Mr. Gisborne hired a hitman. Isn't that right?
Yeah, we hired a man named Tucker Frierson.
And you hired that man to kill Miss LaHood. That's your story.
That's right.
Now, you claimed on direct examination that Miss LaHood knew about who hired that hitman.
She did. Tucker had told her that we had hired him.
And you believe that based on a conversation that you had with this guy, Tucker, right?
That's right.
Fair to say, Mr. Scarlett, that you're the only person who can tell us whether that conversation actually happened?
I'm not sure what you mean.
You're not aware of anyone else who overheard that conversation?
Yeah, I don't know if the doctors or the nurses were listening, no.
And the guy who allegedly made that statement, he's dead now.
He died the very next day.
So you're not aware of anyone who can corroborate your story about that conversation?
That's right. I don't know anyone else.
I want to ask you about something else now, different. Fair to say, Mr. Scarlett, that you have an allergy to peanuts?
That's 100% fair to say.
That allergy is deadly?
It is. Even just being in the room with peanuts can cause me to act up.
You can die if you ingest peanuts, right?
Absolutely.
You go into anaphylactic shock?
Yeah, my throat will start to close up.
I want to talk to you about who knew about your deadly peanut allergy. Certainly you told your boyfriend, Mr. Gisborne, about that allergy, right?
I think he knew about it, yes.
You'd actually had an allergic reaction in front of Mr. Gisborne before.
Yes, I'm sure I have.
And when you had that same allergic reaction, Miss LaHood was also there.
I don't know which specific time you're talking about, but maybe.
Sir, you had a dinner one time, right, with Miss LaHood and Mr. Gisborne?
I've had a lot of dinners with them. I'm sorry. We were in this fake marriage thing for like 2 years.
All right, sir, do you recall an instance in which you were at dinner and you had an allergic reaction in front of Miss LaHood and Mr. Gisborne?
Yes. I'm sure one happened.
And Miss Mariansky was also present for that allergic reaction, right?
Yes.
Fair to say that those three people all knew about your peanut allergy.
Yes, I think everyone knew.
Then let's talk about what happened on August 6th of 2020. When you got to that woods that night, sir, you said that you saw Mr. Gisborne take something out of his pocket, right?
Yeah, he was taking out the condom, yeah.
And when you noticed that when Mr. Gisborne took out the condom from his pocket, you saw that it wasn't sealed.
That's right, it was already opened.
You don't know why Mr. Gisborne took out an already opened condom.
I imagined he didn't want to fiddle with the wrapper, kind of kills the mood, but I don't know for sure.
That's a yes to my question, sir. You don't know why he took out an already opened condom.
I don't know for sure.
And you don't know what substances may have been on that opened condom.
I didn't know at the time, no.
What you do know is that it was only after Mr. Gisborne reached into his pocket that he was hit with that arrow.
Yes, it was after, yes.
I want to ask you more about what you saw when the arrows were shot. And what I want to do, sir, is focus here on what you actually saw versus what you didn't see.
Okay.
Fair to say that after the arrow was fired, you saw someone off in the distance.
Yes, I did see some, but just the silhouette.
You didn't see that silhouette in the distance load a second arrow.
No, I couldn't tell from where I was.
And you didn't see that silhouette in the distance fire a second arrow.
No, when the second arrow was shot, my back was turned and I was running.
The truth is, sir, what you saw that person in the distance do was turn away from you and back towards the house.
Yeah, at first.
Sir, you didn't see who shot the second arrow.
I didn't see it, no.
And you didn't see if it was the same person or someone else.
I mean, who else could it have been? I was in Robin's backyard and she's an Olympic level archer. I mean, it was Robin.
Sir, I'm not asking you to speculate as to what you think happened. I'm asking you what you saw happened. And you didn't see whether the same person shot both arrows.
No, I didn't see it, no.
Thank you, Mr. Scarlett. I have nothing further, Your Honor.
Very well. Any redirect?
No, Your Honor.
Very well, we may proceed to the next witness.
Your Honor, the state calls Detective Figton. May I proceed?
You may.
Good morning. Can you please introduce yourself?
Good morning. My name is Newt Figton.
What do you do for a living?
I'm a detective sergeant with the Buffalo-Niagara Police Department.
How long have you been with the Buffalo-Niagara Police Department?
I've been there for some like 27 years now. I was promoted to detective in 1998, and I've been a detective sergeant since 2013.
What kind of work do you do as a detective sergeant?
I handle major crimes, so murder, robbery, assaults, you name it.
Hey, Detective, I'd like to switch gears and talk about today's case. How did you become involved in today's case?
Well, on August 6, 2020, I received a call from dispatch at around 7:30 p.m. A couple of kids had been trespassing in the woods by the LaHood estate, and they found the body of a man who'd been shot with a bow and arrow.
Well, you just mentioned the LaHood estate. Do you know the owner of that estate?
Yes, I do. She's Robin LaHood, the defendant in this case. She's also the CEO of Nottingham Sporting Supply and an Olympian archer.
Now, Detective, I know because of our virtual setting, our cameras may be off and you may not see the defendant, but do you recognize that the defendant is present in the courtroom today?
Yes, I do. The defendant should be in a box that says Robin LaHood.
Your Honor, let the record reflect that the detective has identified that the defendant is present.
The record shall so note the identification of the defendant by this witness.
So, Detective, after you received this phone call, did you go to the LaHood estate to investigate?
Yes, I did. I arrived at the scene around 7:45 p.m. A few officers had arrived before me and they led me to the body.
Can you tell us what you saw?
I saw a deceased white male laying on his side. I now know that this man is Guy Gisborne, and he had a fixed blade, broad-headed arrow protruding from the center of his chest with about 4 inches of the arrow shaft sticking out as well.
Was a photograph taken of this body at the scene?
Yes, it was.
Would you recognize a photograph of the body if I showed it to you today?
Yes, I would.
Your Honor, I'm showing opposing counsel and the witness what has been marked as State's Exhibit 42. Detective, is this the photograph of the body that was taken at the scene?
Yes.
Is it a fair and accurate representation of the body as you saw it that day?
Yes, it is.
Your Honor, the state moves to enter Exhibit 42 into evidence. In pretrial, opposing counsel agreed that this photo is admissible.
The photo is admitted.
So, Detective, based on what you saw in this photograph, did you reach any conclusions about the killing of this man?
I concluded that the victim must have been shot from behind based on the position of the arrow and the entry and exit wounds on the back and chest.
Was there anything else in this photograph that was of importance to your investigation?
Well, I noticed that there is a partially open condom in the victim's hand. At this point, I thought that he might have been engaged in or perhaps about to engage in some sexual activity. So I thought that there might be someone else who'd been present at the time of the murder.
Detective, did you find any other evidence at the scene that day?
Yes, we found a second arrow that was the same make and model as the first.
Would you recognize a photograph of this arrow if I showed it to you today?
Indeed, I would.
Your Honor, I'm showing opposing counsel and the witness was marked as State's Exhibit 57. Detective, is this a photograph of that arrow?
Yes,
Is it a fair and accurate representation of where you found that arrow that day?
yes, it is.
Your Honor, the state moves to enter Exhibit 57 into evidence. Again, opposing counsel has agreed in pretrial that this document is admissible.
57 is admitted.
Detective, can you tell the members of the jury where exactly you found this arrow?
Yes, I can. I found it lodged in a tree about 40 to 50 yards behind where the victim's body lay. The arrow was about 4 to 5 feet above the ground.
And did you notice anything about the environment in which you were finding all of this evidence?
Yes, I noticed that some of the bushes between the body and the second arrow had been disturbed, as if someone had run through them.
So what did all of this indicate to you?
Well, this also indicated that a second person was there. I thought that maybe they had run away and the killer had tried to hit them, but missed their mark.
Objection lacks foundation. May I explain?
You may.
Specifically to the end of the detective's answer, that one killer had tried to target both individuals and missed the second individual. We haven't heard foundation for the detective to give that opinion.
Your Honor, may I respond?
You may.
The detective isn't making an opinion that there was one killer that day. He's only testifying that based on what he saw, it looked like someone had run through the bushes and someone had launched an arrow at them and missed that person, and it had landed in the tree. He's reaching no conclusions about how many killers were there that day or how many people were shooting, just that it looks like to him, based on what he had recovered, that someone had run in that direction and an arrow had missed them and landed in the tree.
May I respond?
You may.
Your Honor, the detective testified that he believed that the killer had targeted both victims but missed the second shot. That was just his verbatim testimony just now, and I'd move to strike that portion of the answer because it lacks foundation.
Objection sustained. Strike the answer. You may proceed or restate your question, Ms. Conway.
So, Detective, what did all of this evidence indicate to you?
I apologize, Ms. Conway. Are we still referring to the second arrow?
Yes, and the bushes that you mentioned on your previous answer.
Well, this indicated that a second person was at the scene and perhaps they had run away at some point.
Thank you, Detective. So based on all the evidence that you recovered, did you have any idea where the shooter may have been standing?
Yes, there was a fallen tree behind the victim's body.
Objection, Your Honor, lacks foundation. May I explain?
You may.
We haven't heard any foundation under 702, but this detective is equipped to make that the opinion about the location of the shooter relative to where the two arrows were recovered. We haven't heard that he has been trained in that sort of triangulation and crime scene reconstruction, that he was applying any reliable principles and methods when he did it in this case, or that his opinions about where the shooter was located were the product of those reliable principles and methods. Without that foundation, it's improper for him to give that opinion at this point.
Your Honor, may I respond?
Briefly.
We're not offering this detective as an expert. We're not trying to enter him under Rule 702 to make a scientific conclusion. The detective, if I may proffer, is going to testify that this spot was the only place that lined up visually with both arrows, and he found evidence of a broken piece of arrow, of the arrow that was found in the tree. He found a broken piece of that arrow behind the fallen tree that he's mentioning. We're not asking him to come to an expert conclusion. We're asking him to lay out the evidence that he found throughout his investigation and the conclusions that he makes going forward.
Response to that, Your Honor?
I've heard enough. The The objection is overruled. However, Ms. Conway, why don't you proceed to the foundation before the conclusion? The objection is overruled because Mr. Warner or his co-counsel will have an opportunity to cross-examine this witness if he feels that the conclusions drawn were unsupported by the facts. Ms. Conway, I suggest you rephrase your question or ask a different question as to any foundation you seek to lay for an opinion by this witness. He is a lay witness, correct?
Yes, Your Honor.
Very well. You may proceed.
Your Honor, may I just quickly clarify that ruling?
You may.
If they don't lay adequate foundation to support an opinion about where the shooter was located, may I re-raise my foundational objection?
You may.
Understood, Your Honor.
My detective, without making any conclusions, I want to talk about this spot behind the fallen tree. How did this spot line up visually with the body of Guy Gisborne?
Well, it lined up as a clear vantage point with where the first victim was hit.
Did you find any other information near that tree or any other evidence near that tree?
Yes, I did. I also found a piece of plastic, the fletching from the end of an arrow behind the tree that our forensic team matched up with part of the second arrow that had been lodged in the tree.
Would you recognize that piece of plastic and that second arrow if I showed them to you today?
Yes, I would.
And I'm showing opposing counsel and the witness was marked as Exhibit 71. Detective, is this that arrow and that piece of fletching you just mentioned?
Yes, it is.
Is it a fair and accurate representation of that evidence?
Yes, it is.
Your Honor, the state moves to enter Exhibit 71 into evidence. Again, defense counsel had agreed in pretrial that this exhibit is admissible.
71 is admitted.
So detective, how do these two pieces of evidence fit together?
Well, as you can see, they fit together perfectly, as my forensics team confirmed. I thought that maybe this piece had broken off when the shooter let their arrow fly behind the fallen tree.
Detective, where was that spot behind the fallen tree? How did that line up visually with the second arrow you found in the tree?
Well, this shot would have been trickier as there were trees and bushes on either side, and there's really only one clear path to where the arrow lined up in the tree.
Now I want to talk about how far away this spot was. How far away was the spot behind the tree from the body of Guy Gisborne?
From the body of Guy Gisborne, about 65 yards.
And how far away was it from the second arrow found in the tree?
The second arrow traveled about 110 yards, so more than a football field.
All right, so detective, after collecting all of this evidence, what did you do next?
I went to the house and I wanted to speak with the owner of the property, Miss LaHood. When I got there, she was with her housekeeper, Marianne Mariansky, and I told her that someone had been killed in the woods on her property.
Well, how did the defendant react to this news?
Well, she asked who, and when I showed her the photo of the body, she identified him as her ex-husband, Guy Gisborne.
Did she explain why her ex-husband was on her property?
Yes, she told me that he'd been living on her property in the guest house since the two had gotten divorced.
Did the defendant explain why, if they were divorced, Guy Gisborne was living in her guest house?
She told me that he was supposed to receive some large amount of money according to their prenuptial agreement. He was short on cash, so he was staying at the guest house.
Did you learn anything else from the defendant?
The defendant just said that earlier that evening, she'd seen Mr. Gisborne going into the woods with Mr. Scarlett. She said she thought they were going for a walk. At this time, she didn't give me any more information, so I just took her business card and decided to leave and follow up later.
Did you ever receive any more information about this case?
Yes, I did. I received a phone call from a man called William Scarlett.
Who is William Scarlett?
Guy Gisborne's partner.
Was this phone call from William Scarlett important for your investigation?
Yes, it was. After hearing what I heard in this phone call, I tested Robin LaHood's DNA. She was now the primary suspect.
So what did William Scarlett say to you on the phone?
Objection, Your Honor. Calls for hearsay.
Your Honor, may I respond?
You may.
The statement that we're going to have the detective say is that William Scarlett called him, told him he had information about the murder, that he thought it had to be Robin LaHood that was the shooter. And then he asked for a deal for leniency for some of his other convictions in return for his cooperation. Now, we're not offering any of these statements for the truth of the matter asserted. We're not trying to prove through the statements of William Scarlett that Robin LaHood was the shooter. The detective testified that after hearing this information, he considered the defendant the primary suspect and immediately tested her DNA. We're just offering these statements for the effect on the listener, the subsequent action of Detective Figton through the course of his investigation.
Response, Your Honor.
May.
They certainly are offering these statements for the truth. The state's whole theory of this case is that Miss LaHood was the sole shooter. And these statements that she was the shooter, that Mr. Scarlett had the belief that she was the shooter, would be offered for the truth to go to establish that point. They can certainly ask this detective about what he did in his investigation without eliciting this statement.
Your Honor, may I respond to that?
Yes.
The state is asserting today that the defendant was the shooter of both of those arrows, but the defendant has admitted to shooting at least one. So we're not trying to prove that whole case theory through the statements of one witness. To testify or to have the detective testify to his next steps throughout the course of the investigation without telling the jury why he took those steps is an incomplete picture of all of the evidence the detective collected that day. Again, we're not offering this for the truth of the matter asserted. We're not trying to prove our whole case through a statement by William Scarlett to the detective. We're just offering this to show context for the next steps he took in his investigation, which was to test the DNA of the defendant.
The objection is overruled. I was going to sustain the objection. The last statement by Ms. Conway led to my overruling the objection. You may proceed.
May we ask for a limiting instruction, Your Honor, that the jury shouldn't take this statement for the truth, but just to contextualize the detective's subsequent action?
You certainly may, and I think that is a very appropriate request, and I will give such a limited instruction. Let's move it along with Ms. Conway.
Yes, Your Honor. So, Detective, what did Mr. Scarlett say to you?
He called me and told me that he had information about Guy Gisborne's death. He says that he was there that day and that Miss LaHood had to be the shooter.
Well, let's back up. Did Mr. Scarlett tell you why he was giving you this information?
He said that he wanted to make a deal for anything he might be charged with regarding a break-in that he was involved with at Miss LaHood's estate.
Can you tell us a little bit more about that break-in?
Of course. Mr. Gisborne had a deal with LaHood in which they would get married so that she could get her inheritance and he would get money in return. Gisborne hadn't gotten his money yet, so Mr. Scarlett found him a hitman to break in and kill Miss LaHood.
So after hearing all this information from Mr. Scarlett, what did you do next?
Our lab tested Miss LaHood's DNA to see if it matched any of the DNA found on the evidence at the scene.
And did your lab prepare a
Your Honor.
DNA report?
Objection.
Wait a
Your Honor.
minute. Did I hear an objection?
Yes, Your Honor. Misstates evidence. May I explain?
You may.
We don't believe that the DNA test that the police lab ran was actually on Miss LaHood's DNA. It was on DNA that was recovered from a business card that she handed to the detective. But there's no foundation that Miss LaHood was the only one who ever came in contact with that business card, or that the lab was able to confirm that the DNA recovered from that card was in fact Miss LaHood's DNA. So for the detective to testify that Miss LaHood's DNA was tested, that misstates the results of that lab test. And if I can voir dire the witness, I'd be able to establish that Miss LaHood's DNA wasn't tested, just whoever's DNA was on that business card was.
Your Honor, may I respond?
You may respond, but you might want to consider restating the question a little differently, Ms. Conway. You can do either one. You can respond or you can withdraw that question and ask another question.
Well, I think I might take a chance at responding if that's all right. We have a DNA report that was prepared by the detective's lab. And in that report, it states that the defendant's DNA was matched with the evidence at the scene. And defense counsel has stipulated that the results of that report are accurate. So to stipulate that those reports are accurate and then in trial to claim that we have no foundation that that's her DNA It's improper. They had the opportunity to review that evidence and raise any objections prior, but they've stipulated to its accuracy.
Your Honor,
But
Mayor,
wait. They may have stipulated, but is that report in evidence, Ms. Conway?
Well, Your Honor, that's my next step. If you'll allow me, I can enter into evidence right now.
You can, if that's up to you. I've not ruled yet. If you want to withdraw your question and offer that exhibit, you may do so. Is that your choice?
Certainly, Your Honor.
Very well.
Detective, did your lab prepare a report summing up the findings of any DNA testing that it may have done?
Yes,
Would you recognize that report if I showed it to you today?
yes, I would.
Your Honor, I'm showing opposing counsel and the witness was marked as Exhibit 99. Detective, is this that DNA report?
Yes, it is.
Are the contents of this report fair and accurate?
Yes,
Your Honor, the state moves to enter Exhibit 99 into evidence. Again, pursuant to stipulation 19, defense counsel has agreed that the information in this report is accurate and is admissible.
99 is received in evidence.
So detective, based on the information in this report, did you find any matches between the defendant's DNA and any evidence at the scene?
yes, the DNA from Miss LaHood's business card was found on the arrow that killed Guy Gisborne.
objection, Your Honor. Non-responsive. First, the question was whether or not they found Miss LaHood's DNA. The witness answered they found whoever's DNA was on the business card on that arrow. It's a non-responsive answer, and counsel's question misstates the contents of the DNA report.
Your Honor, I'll rephrase my question.
Good idea. You may.
Did you have any matches from the female DNA profile that was found on the defendant's business card and any of the evidence at the scene?
Yes, the DNA from the business card was found on the arrow that killed Guy Gisborne.
Did you tell the defendant that that DNA was found on the arrow that killed Guy Gisborne?
Yes, I called her and I told her that I wanted to come speak with her again. She insisted on hearing what new information we recovered first, so I told her about the DNA.
And at this point, did you get a warrant to search the defendant's home?
Of course.
So when you arrived at the defendant's home, how did she appear to you?
From what I could tell, she seemed pretty calm.
Did she say anything to you?
She told me that she had what I was looking for and handed me a bow and arrow.
Would you recognize that bow if I showed it to you today?
I would.
Your Honor, I'm showing opposing counsel and the witness was marked as State's Exhibit 66. Detective, is this the bow you recovered from the defendant that day?
Yes,
Is that a fair and accurate representation of that bow?
yes,
Your Honor, the state moves to enter Exhibit 66 into evidence. Again, opposing counsel and pretrial agree that this evidence is admissible.
I'm going to admit it. I have a question for you, Ms. Conway.
Yes,
Are
Your
you
Honor.
presenting that as a long bow or a crossbow?
It's a long bow, Your Honor.
Very well, 66 is admitted.
So detective, after the defendant handed you this bow, did she say anything else?
yes. Her story was completely different during this visit. She confessed to killing Mr. Gisborne.
Did she tell you why she killed him?
Yes, she said that she killed Mr. Gisborne in order to stop him from killing William Scarlett.
Did the defendant tell you why she thought Guy Gisborne was going to kill William Scarlett?
She says that Miss Mariansky had told her that she overheard Mr. Gisborne discussing how Mr. Scarlett was deathly allergic to peanut oil.
Well, how does that relate to the events of August 6th?
Well, Mariansky and LaHood saw the two men walking out into the woods together. Mariansky then told LaHood that Mr. Scarlett was in danger, and LaHood ran out to the woods to follow them.
Did the defendant tell you anything else?
She told me that Mariansky was actually the one who shot the second arrow that we found in the tree.
Detective, based on that DNA report, did your lab reach any conclusion regarding any DNA on that second arrow?
No, the results were inconclusive.
Did you tell the defendant that there was no conclusive DNA results for that arrow?
Yes, I did over the phone. She just said, quote, "Oh, okay, interesting."
Did she tell you why Marianne Mariansky supposedly shot this arrow?
Yes, and it's a little complicated. She said that Mariansky shot at William Scarlett in order to have leverage against Miss LaHood, to force LaHood to leave everything in her will to Miss Mariansky.
Did you find the bow that Miss Mariansky supposedly used to shoot this arrow?
No, we didn't find any evidence of this bow.
Well, did your lab test the bow that you did recover?
Yes, and we found more of the female DNA on it.
The DNA from the defendant's business card?
Yes.
Did you find anything else about this bow?
Yes, our lab did a demonstration with the bow, which I was present for. A lab tech fired the bow that we recovered from the defendant with the arrow from the tree.
And was a report prepared for this demonstration?
Yes.
Your Honor, I'm showing opposing counsel and the witness, which was marked as State's Exhibit 98. Detective, is this that report from that demonstration that your lab did?
Yes, it is.
Is it a fair and accurate representation of those results as you remember them?
Yes.
Your Honor, the state moves to enter Exhibit 98 into evidence pursuant to that same stipulation 19. Both sides have agreed this document is accurate and admissible.
98 is received.
Detective, based on the information that's in this lab report, did you learn anything else about that bow?
Well, we determined that in order to draw the bow, the shooter would have to pull 50 pounds of what's called draw weight to fire the arrow.
And Detective, can you tell the members of the jury what Miss Mariansky's build is like?
She is quite small, standing at about 5'2" and maybe 110 pounds.
All right, Detective, I want to make one last thing very clear for the members of the jury. When was it exactly that the defendant changed her story and admitted to killing Guy Gisborne?
She confessed after I told her that I had DNA from her business card on the arrow that killed Mr. Gisborne.
And when did she tell you that it was Marianne Mariansky who shot that second arrow?
Only when we told her that her DNA was not found on the second arrow.
Thank you, Detective. I have no further questions.
Cross-examination,
Yes, Your Honor, may I begin?
you may.
Good morning, Detective.
Good morning, Mr. Warner. How are you?
I'm doing all right. Thank you for asking. Sir, you've been with the force for 27 years at this point, right?
Give or take.
You've worked hundreds of murder and attempted murder cases. Do I have that right?
I don't keep track, but that sounds about right.
So you'd agree that when you conduct an investigation, it's important to be impartial, wouldn't you?
Of course.
Important to be thorough, right?
That's correct.
It's important to collect all relevant evidence. Isn't that true?
Of course, the evidence is what points us to the truth.
And you said something interesting on direct examination that I wanted to just start by following up on. You told us you didn't find any evidence that Miss Mariansky had a bow that night. Do you remember saying that?
Yes.
Detective, the truth is you never bothered to ask to see the bow she had.
No, she told me that she destroyed it.
Is it your testimony Miss Mariansky told you she destroyed that bow?
Those may not be the exact words, but we didn't find any evidence.
That wasn't my question. My question was whether or not at any point you say that Miss Mariansky told you she destroyed that bow. Yes or no?
No. Apologies.
The truth is, Detective, the only reason you don't know whether or not she had a bow is because you didn't bother to ask. Isn't that right?
That's correct.
Then let's talk about how this investigation started. You spoke with Miss LaHood just a short time after finding the body, didn't you?
That's correct.
But when you spoke with her, you already believed she was a suspect, didn't you?
That's correct. At the time, that's where all the evidence was pointing.
I want to be clear about what evidence you had at that point. At the point at which you decided to treat her like a suspect, you hadn't spoken to a single eyewitness, right?
No.
You hadn't run a single forensic test, right?
No.
You told us the evidence pointed to her. At that point, Detective, you didn't even know the victim's name, did you?
I knew that there was a body shot with a bow and arrow on the property of an Olympian archer.
Detective, that wasn't my question. My question was whether or not, at the point at which you decided to treat her like a suspect, you knew the victim's name, did you?
No, I did not.
And you told us an investigation should be thorough. So I want to talk about what you did and didn't do in this case. Now, like you told us on direct examination, you actually had someone come forward and admit to firing that second arrow, didn't you?
She claimed she did. I didn't find it to be believable.
That person was Marianne Mariansky, right?
That's correct.
And at that point, you knew that she lived at the same house as Miss LaHood, right?
That's true.
You knew she was there the night of August 6th, right?
That's correct.
You knew she had access to the same bows and arrows that Miss LaHood did, didn't you?
I can assume so.
But you didn't ask Miss Mariansky to come down to the police station to give a statement, did you?
No,
You didn't ask Miss Mariansky to walk you through the crime scene, did you?
no,
You didn't ask her for a DNA sample, right?
no,
Or a fingerprint sample, right?
no.
I mean, detective, the truth is you didn't even file a written report about this case, did you?
No, I didn't.
Then let's talk about the evidence you did have about who shot that second arrow. You recovered the second arrow, the one that was fired at Mr. Scarlett, and you sent it to the police lab for testing, right?
That's true.
You had them run a series of forensic tests on that second arrow to try to figure out who shot it, right?
That's correct.
The police lab was unable to conclude that Miss LaHood's DNA was on that arrow. Isn't that true?
That's correct. We did not have enough DNA on the arrow in order to link it to Miss LaHood.
They were unable to conclude that Miss LaHood's fingerprints were on that arrow, right?
That's correct.
They were unable to conclude whether or not Miss LaHood had ever touched that arrow in her life. Isn't that true?
Well, that seems unlikely given her profession, but that's correct.
I'm just asking what the lab was unable to conclude or not. And they weren't able to conclude that she had ever touched that second arrow, were they?
They didn't find her fingerprints on it, is what I'll say.
Then let's talk about the bow Miss LaHood had. Now you determined that the second arrow was recovered 110 feet away from where the fletching was found, right?
That's not correct. You said 110 feet.
110 yards, apologies, detective.
Bingo.
And you sent that bow to your ballistics lab to try and figure out how it fired, right?
Yes, sir.
But you didn't have that lab try to fire that bow 110 feet, did you?
Why would that be necessary?
Detective, my question was whether or not you had your ballistics lab try to fire that bow 110 yards. And you didn't, did you?
No, that was not necessary.
The maximum distance you tried to fire that bow was just 65 yards, wasn't it?
That's correct.
Sitting here today, you don't know whether or not that bow can fire 110 yards, do you?
We didn't find out via test.
Then I want to talk about Mr. Gisborne. Because Miss LaHood, she explained why she thought she needed to shoot him, right?
Yes.
Like you said, she was worried that he was going to kill Mr. Scarlett with peanut oil. Isn't that true?
Yes, a poison condom, I believe.
And detective, you did find a condom on Mr. Gisborne's person, didn't you?
Yes, this is where the peanut oil was.
That condom was open, right?
The package was, at least.
And you sent that condom to the same police lab to be tested, didn't you?
That's correct.
The police lab found peanut oil on that condom, didn't they?
They found the acids that are associated with peanut oil on it, yes.
Detective, you know that Mr. Scarlett has a deadly allergy to peanut oil, don't you?
I know it's certainly severe.
Thank you. No further questions, Your Honor. Although at this point, may I read a stipulation onto the record?
Well, yes, you can. Please identify the stipulation
Yes, Your Honor, I will. This is
before reading it.
This is stipulation 21. It reads, the exterior of the condom.
Oh, wait a minute.
Hmm.
Ms. Conway, do you have a copy of the stipulation?
Pulling it up now, Your Honor, but I think I know where defense counsel is going with it, so I don't have any objection to him proceeding.
All right, he may proceed to read that stipulation into the record if he wishes.
The exterior of the condom was tested at the forensic lab and tested positive for peanut oil. That's the end of the stipulation, Your Honor.
And that's the end of your examination?
It is, yes.
Any redirect, Ms. Conway?
No redirect, Your Honor.
Very well. You may call your next witness, if any, Ms. Conway.
Your Honor, at this point, the prosecution rests our case in chief. And if it's all right with defense counsel and Your Honor, we'd like to request a brief 5 to 10 minute recess.
All right, before we consider any recess, are there any motions?
Yes, Your Honor. The defense does have a motion. Under Rule 29, we'd like to move to dismiss just that second charge, the charge regarding the attempted murder. May I explain?
Yes.
Even viewing the evidence in the light most favorable to the non-moving party, the state, no reasonable finder of fact could conclude beyond a reasonable doubt that Miss LaHood was the individual who shot the second arrow at Mr. Scarlett. There is no eyewitness testimony confirming that she was the shooter of both arrows. There's no forensic evidence connecting her to that second arrow. And in fact, all the eyewitness testimony we have heard indicates that it was someone else. It was Miss Mariansky. So even viewing those facts in the light most favorable to the state, no reasonable finder of fact could conclude that she shot that second arrow. So we move to dismiss the attempted murder charge.
Your Honor, may I respond?
Yes, but before you do, I have a question. This is a Rule 29 motion. Are you telling me that you're not moving to dismiss both count 1, the murder count charge, and count 2? You're only moving to dismiss count 2?
No, Your Honor, for purposes of preserving our right to appeal, we would certainly move under Rule 29 to dismiss both charges. But here we just want to focus the argument on the second charge.
Okay, so you think the merits of your motion might be better on the second charge?
Well, I think we have merits on both charges, but here I would like to focus on the second one.
Very well. We'll hear what Ms. Conway has to say about your motion, and then we'll take up the issue of a break, and I'll ask the timekeeper how we're doing with time so far when we take up that issue. Ms. Conway.
Yes, Your Honor.
Heard.
As Mr. Warner stated, these facts have to be looked at in the light most favorable to the state. And as we've shown throughout our case in chief, a reasonable jury could find that it was the defendant who shot this second arrow. We heard from William Scarlett today, who testified that Marianne Mariansky, though she's claiming to have shot this arrow, was not a very good shot. She couldn't have hit the broadside of a barn. You heard from the detective today that the shot from where the person was standing, the shooter was standing, and where that second arrow was found in the tree, that was 110 yards. That's longer than the length of a football field. And that shot was obscured by trees and branches and bushes. And you heard from William Scarlett that the only reason that arrow didn't hit him was because he fell at the last minute. Marianne Mariansky couldn't have made that shot. Only the defendant, the Olympian level archer, could have made that shot. You also heard that Miss Mariansky was physically incapable of firing the only bow that we have in evidence, because that bow required 50 pounds worth of draw weight. Marianne Mariansky is 5'2" and 110 pounds. And again, she's not a competent archer. We have proven today throughout our case in chief that a reasonable jury could find it was the defendant who fired that arrow. And so these factual issues should go to the jury.
May I respond, Your
Honor? Briefly.
Yes, the question here isn't whether or not Miss Mariansky was the shooter. It's whether or not there's enough evidence for a reasonable finder of fact to conclude that Miss LaHood was the shooter. And we actually haven't heard sufficient evidence for a reasonable finder of fact, even construing the evidence in the light most favorable to the state, to make that determination.
Well, viewed in the light most favorable to the state, and considering that this is primarily a circumstantial evidence case, and that it is going to turn on how much weight the jury is going to give the credibility and believability of the witnesses, the motion under Rule 29 is denied. Now, let's take up the issue of Ms. Conway's request for a brief recess. How long of a recess are you requesting, Ms. Conway?
Anywhere between 5 to 10 minutes, Your Honor.
And the reason why you think we should take a recess?
I would personally really enjoy a recess. I don't know if my fellow attorneys and competitors agree.
This is
All right.
a joint motion here, Your Honor, by both parties for the recess.
Okay. Well, I thought it was a fair question. Why do you want a recess? I do like to move things along, but I also believe that sometimes with a brief recess, the parties are more refreshed and can better move things along after a brief recess. What do you think of that?
Sounds good to me, Your Honor.
All right. Now, what about, I just saw a chat about time, but I haven't had a chance to study it. How are we doing on time? At the pace that we're going, even with a recess, are we going to have a time problem?
It doesn't look like it, Your Honor.
All right. So let's keep it moving along. And what is the time now, Miss Conway?
My clock says 10:31, Your Honor.
10-minute recess. You may turn off your videos and refresh yourselves. And I will expect to continue at 10:41 sharp. Thank you.
Thank you, Your Honor.
Your Honor.
That's what I do in the law classes. Very well. It looks like everybody's present and accounted for. I'm really not as gruff as I look. I hope I haven't frightened anybody with my voice and the fact that I look like a grizzled old judge. I can see why both teams have advanced so far. I attribute it to the fact that they must have great coaching. And the witness who played Fig Newton, I don't know if he's pursuing a career in law, but if that doesn't work out, he should try acting, because I think he's done a splendid job as a witness in this case. I don't give credit. I don't score the lawyers based upon the witnesses. I assure you of that. But I just wanted to say I'm rather impressed. With that, we will proceed to the defense case. Who will call the first witness?
That would be me, Your Honor.
Very well, you may proceed.
Yes, Your Honor. The defense calls Miss Marianne Mariansky. Good morning.
Good morning, Mr. Barilli.
Can you please state your full name for the jury?
Yeah, my name is Marianne Mariansky.
And what do you do for a living?
I'm sort of a stay-at-home girlfriend. I live with RJ. I do her cooking, her cleaning, her hair, her nails. I dress her. Let me tell you, it's a full-time job.
You mentioned that your girlfriend's name is RJ. Who's that?
RJ, Robin Jane LaHood, the person you've been talking about this whole time.
And how would you describe your relationship with Miss LaHood?
Look, I devoted my life to that woman, but she kept treating me like I was nothing. Kept told her family I was her housekeeper, her servant. I only played along because she kept promising to buy me this and that, and I got to see her every day. Because let me tell you, it is not in my nature to serve people.
So given all of that, why would you stay with Miss LaHood?
What was I going to do? I was always taking care of RJ. And after all those years, I was waiting for her to give me something for once.
What do you mean by that?
Money. She had it and I wanted it. So I was waiting to get what I'd earned. I'm real romantic like that.
Miss Mariansky, do you also know a man by the name of Guy Gisborne?
Yeah, I knew Guy. Had to be there when he married RJ. God, was it not the worst day of my life? Let me tell you, the dress she had me wear, not flattering.
And when Mr. Gisborne and Miss LaHood got married, did your relationship with Miss LaHood change?
Nah, RJ and I still lived up in the main house together, and Guy lived in the guest house with Will, his boyfriend, Will Scarlett. But the whole time I had to keep up the stupid housekeeper act. Humiliating.
Then I want to change your attention to the evening of August 6, 2020, the night that Mr. Gisborne was shot. Do you recall that night, Miss Mariansky?
Yeah, I do.
Where were you?
I was at the house, at RJ's house.
Was Mr. Gisborne also at the house that evening?
Yeah, he was around.
Now, the first time that you saw Mr. Gisborne on August 6th, what was he doing?
He was yammering on the phone right outside my window as I was trying to do my makeup.
Were you able to tell what Mr. Gisborne was saying on the phone?
Objection, Your Honor. The question calls for hearsay.
May I respond, Your Honor?
You may.
I have a good faith belief that the statement that will be elicited will be that Mr. Gisborne was saying on the phone that he was worried about William Scarlett and what he might do in the future about it, and that he would also say that Mr. Scarlett had to go. That statement satisfies the 803(3) exception for statements of intent, motive, or plan of the declarant, in this case, Mr. Gisborne.
Any response?
Your Honor, I'll admit that those are certain phrases that Ms. Mariansky may have overheard. That being said, to sort of suggest that those few scattered statements that Ms. Mariansky overheard Ms. Gisborne say while he was on another floor in another part of the house, to sort of suggest that that constitutes a motive, intent, or plan is a bit of a stretch and doesn't quite fall to that muster that 8033 requires.
Overruled. You'll have a chance to cross-examine this witness. You may
Yes, Your Honor.
proceed.
So Ms. Mariansky, let's come back to that phone conversation that you overheard. What was it that you heard Guy Gisborne say on the phone?
Yeah, I kept seeing how he was worried, real worried about Will, about what he might do, that he had to go.
And when you heard that, what did you do?
I mean, I ran downstairs to talk to RJ to tell her what I'd heard.
And what did you tell Miss LaHood about what you heard Guy Gisborne say?
I told her I heard Guy on the phone saying that he wanted Will gone, that he wanted to kill Will, and that he sounded real serious.
Well, hang on for a second, Miss Mariansky. You just told us a few moments ago that you heard Mr. Scarlett say that, excuse me, Mr. Gisborne say that Mr. Scarlett had to go. Why would you tell Miss LaHood that he was going to kill Red Scarlett?
Well, after he said that Will had to go, he kept mentioning peanut oil. That's what made me think about it.
Why did hearing about peanut oil make you think that?
Because Will's real allergic to peanuts. So Guy talking about wanting him gone and using peanut oil, I mean, it didn't take no rocket scientist to figure that out.
So what did Miss LaHood say after you told her that Guy Gisborne was going to kill Red Scarlet?
She said we had to stop it. We had to do something. And that's when I saw Guy bringing Will out into the woods. And I said, RJ, look, they're going right now.
What did Miss LaHood do?
RJ ran and grabbed a bow and arrow and started running after them.
What about you? What did you do?
Well, I got to thinking and I realized that, I wanted to be involved too. So I got a bow and arrow and I ran after her into the woods.
And when you got into the woods, what did you see?
I saw Guy and Will by a tree. Will was on the ground. And then RJ shot an arrow at Guy and it hit him.
Now, after Miss LaHood shot that arrow at Mr. Gisborne, did you see Miss LaHood load a second arrow?
No, she didn't do that.
Did you see her shoot a second arrow?
No.
And what did you do at this point?
Well, I saw that RJ hadn't shot at Will, and I realized that if I shot my arrow, I could make it look like she tried to kill him too. That's what I did.
Why would you want to make it seem like RJ LaHood tried to kill Mr. Scarlett?
Because I have done everything for RJ, devoted my life to her. And this was my chance to get something in return. I wanted her to owe me.
What do you mean that you wanted Miss LaHood to owe you?
Well, I thought she'd need me to tell the police what really happened. So she'd give me whatever I wanted in return. If I wanted money, she'd have to give me money. If I wanted a ring, well, she'd have to give me a ring too.
And I want to make sure I understand, Miss Mariansky, why are you testifying today if you admit to shooting at Mr. Scarlett?
Well, I wasn't trying to hit him or nothing. It's not a crime to shoot near someone.
All right, then I want to ask you what happened after you shot the second arrow. Did you ever speak to police about this case?
Yeah, a cop came to the house a few hours later.
Did you tell that cop what you just told this jury?
Nah, and we told him we knew nothing. RJ said I freaked her out a little bit and she wanted to wait until she could better understand what I had done. So we waited.
Did you eventually tell the police what happened?
Yeah, a cop came back a few days after that and told him everything.
And did you tell that police officer about shooting the second arrow?
No, when he came back, yeah, I told him everything.
Now, when you told that police officer that you fired the second arrow, did that police officer ask you to walk him through the crime scene?
No,
Did they ask you for a DNA sample?
no,
Did they ask you for fingerprints?
no, I didn't ask those neither.
Did they ask you to come to the police station and give an official statement?
No,
When you told the police that you shot the second arrow, did the police ask you for the bow that you used?
no,
When you told the police that you shot the second arrow, did the police ask you any follow-up questions at all?
no, not a single one.
Thank you, Ms. Mariansky. I have nothing further, Your Honor.
Very well. Now for the cross.
Yes, Your Honor, may I proceed?
You may.
Good morning, Ms. Mariansky.
Come on in.
Ms. Mariansky, you claim you have nothing to hide, isn't that right?
I mean, I'm testifying, so no.
But you've hidden details from law enforcement before in this case, haven't you?
I mean, like I said, initially we said we knew nothing, but then we came clean after.
So that's a yes to my question. You've hidden details from law enforcement before in this case, haven't you?
Yeah,
You hid details about the night of you hid details about what happened on the night of August 6th.
like I said, yeah,
You hid the bow that you allegedly used to shoot at Mr. Scarlett.
sure.
Well, you didn't just quite hide the bow, you destroyed the bow, didn't you?
Threw it away, yeah.
You disassembled the limbs.
Yeah, threw it away.
You put it in the trash and you took out the trash the next morning, didn't you?
Yeah, like I said.
Now, I want to ask you something. You and the defendant both agreed to hide those details from the police, right?
Yeah, like I said.
And in fact, when the defendant told you, rather, when the defendant knew the police were coming, the defendant said that when the police start asking questions, we say we know nothing, right?
Yeah, like I said, she wanted to better understand what I had done.
So that's a yes. The defendant told you that when the police start asking questions, we say we know nothing.
Yeah, that's what we agreed.
Now, I want to talk a bit more about the events of what happened on August 6, 2020. You told the defendant that you were concerned that Mr. Gisborne was going to kill Mr. Scarlett, right?
I did.
And you were concerned because you overheard Mr. Gisborne on a phone call, correct?
True.
And in this phone call, he used the word peanut oil.
He did.
And to your knowledge, you are the only person that overheard Mr. Gisborne, right?
I mean, I don't know who else was around, but I heard it.
So to your knowledge, you don't know if anyone else was around to overhear Mr. Gisborne?
No,
And you don't know who Mr. Gisborne was talking to, correct?
I don't.
Now, you've described Mr. Gisborne as determined to kill You've described the defendant as determined to kill Mr. Gisborne, right?
I describe her as, determined to stop him from killing Will. Yeah.
And the defendant stopped Mr. Gisborne by killing him, right?
I mean, yeah, that's what happened.
Now, I want to explain this to the jury step by step, just so we're clear. You're claiming that the defendant knew that Mr. Gisborne was going to kill Mr. Scarlett that night, right?
I mean, that's what I told her.
So the first thing she does is grab her longbow.
Yeah, I mean, we saw them walking in the woods and didn't realize we had no time to do anything else.
So she grabs her longbow and her arrows,
Yeah,
and she sprints out into the woods after them.
exactly.
She sees Mr. Gisborne.
Well, I mean, I wasn't there with her at that point. I don't know what she saw.
So you think, so it's your testimony today that you don't know whether you don't know much about the vantage point about Miss LaHood, right?
I mean, I followed her, but I'm not exactly sure on your question at what time point you're asking about.
Well, let's talk about when you followed her. You were about 25 yards away before Miss LaHood fired that shot, correct?
Yeah, that sounds right. I'm not good with the math, but that sounds right.
And you didn't yell out to Mr. Scarlett or Mr. Gisborne to stop, right?
No, I was running towards them.
Well, you didn't hear the defendant yell out to Mr. Scarlett or Mr. Gisborne to stop, correct?
No,
You didn't call the police?
I mean, we were hurrying. We had no time.
The defendant didn't call the police?
I mean, I don't think so. No.
So the defendant takes aim at Mr. Gisborne, right?
I mean, she shot him, so I guess she had to.
Right, right. No, so I want to be clear about what you saw. You saw Mr. Gisborne standing over Mr. Scarlett, right?
Yeah. Will was on the ground.
Right. So Mr. Gisborne was standing and facing away from the defendant,
Yeah.
and you saw you saw Mr. Scarlett kneeling in front of Mr. Gisborne, correct?
Correct.
Guy Gisborne, to your knowledge, you didn't see a weapon on him, right?
No, I didn't see much. I was running towards them, like I said.
Right. You didn't see much, correct?
Yeah.
And this entire time, you didn't yell out to Mr. Scarlett that his life was in danger.
I mean, as I said, I was running towards them. I was pretty far away when Andre shot. As you said, 25 yards. I didn't yell out, no.
So that's a no to my question. You didn't yell out to Mr. Scarlett that his life was in danger during any of this time?
No.
Now, you claim that you're the one who shot at Mr. Scarlett, right?
I did shoot at Mr. Scarlett, yeah.
You're 5'2", Miss Mariansky,
I am and proud of it.
and about 110 pounds.
I mean, I don't like discussing my weight, but it's the court of law, so I guess I have to. Yeah, 110, that's where I'm at.
I mean no disrespect, just to get the record straight as to your build. So you're claiming that you shot that arrow 110 yards, right?
I mean, I'm telling you, I shot the arrow. I'm not sure how far away it ended up.
And when you allegedly shot at your half brother, you didn't even know if that arrow was properly aligned on your bow.
I mean, I'm not sure. No, I just shot it.
So I want to really get this straight. You're claiming that you allegedly shot at your half brother with a potentially misaligned arrow, all for insurance?
I mean, yeah, I wanted to get what I'd earned.
You wanted Robin LaHood to remove the NAA from her will, right?
Yeah, I mean, that was part of it. I wanted her to give me more money.
You wanted her to leave the rest of her will to you, correct?
Sure.
And this whole plan of yours, it was all for a payout that was not going to happen until defendant LaHood dies, correct?
I mean, payout, sure, but the gesture that I actually mattered to her, that was happening now.
Now, I want to talk about your relationship with the defendant. You'd consider yourself and the defendant to be fairly close, right?
Of course.
You've been friends since middle school.
True.
You were her archery assistant.
Yeah, I was.
And you've fallen in love somewhere along the way, isn't that right?
You could say that.
Now, this isn't the first time that you've taken the fall for defendant LaHood, correct?
Objection, Your Honor. This is going into the 404B propensity argument that was discussed in pretrial, and I believe Your Honor reserved on ruling.
Your Honor, I'll withdraw the question.
Very well.
Ms. Mariansky, you've been banned by the NAA, haven't you?
Yeah, I have.
And that's because the defendant's main competitor was given horse laxative against her consent?
There was an incident involving horse laxatives.
Your Honor, I think this is going into that same incident. As we discussed, counsel can go into the fact that she's been banned and that she has animus towards the NAA. They can't go into the underlying circumstances.
May I respond, Your Honor?
Yes.
Your Honor, I rather to not go into the details of the motive that that the defense is alleging that Ms. Mariansky had as to why she had that intention to shoot at her half-brother, why she had animus. Well, that tends to prejudice the jury because we're giving them an incomplete picture. And as I had stated previously in pretrial, that the jury deserves a picture of evidentiary fullness. And this testimony goes directly to the reasonableness, or rather the legitimacy of that motive and that intent that Ms. Mariansky had to shoot at Mr. Scarlett, stemming from this event that happened 10 years ago with the NAA.
May I briefly respond, Your Honor?
Yes.
I believe the witness testified that she did what she did because she wanted money and because she felt underappreciated by Ms. LaHood. The NAA does not actually play any fundamental role in the underlying conduct that happened here. And that's why introducing evidence of propensity would run afoul of that. I think at the end of the day, the big picture is that the witness wanted money from Ms. LaHood. She shot that arrow in furtherance of that plan. That doesn't require there to be any propensity reasoning elicited from the incident involving the NAA.
May I respond briefly, Your Honor?
I've heard enough. Objection sustained. Move along.
Yes, Your Honor.
Move to strike, Your Honor, any answer that was given.
It will be stricken.
Ms. Mariansky, you've devoted your life to the defendant, haven't you?
Yeah, I have.
The defendant, she pays you,
She does.
she houses you,
She does.
she financially supports you.
Yeah.
If anything were to happen to the defendant, you'd be out of the job.
Objection, calls for speculation.
May I respond?
Overruled.
Ms. Mariansky, if anything were to happen to the defendant, you'd be out of the job.
Yeah, I had to work somewhere else.
You may need to find a new place to live.
Yeah, who knows?
Thank you, Your Honor. No further questions.
Very well. Cross-exam. Oh, I'm sorry. All right. Any further redirect?
No, Your Honor. Defense has no redirect. We just ask that Ms. Mariansky please be excused.
Oh, yeah. She'll be excused, subject to recall. We may want to hear from her again.
Yes, Your Honor.
All right. Let's proceed to the next witness.
Defense calls Robin Jane LaHood.
Very well.
May I begin?
You may.
Good morning, ma'am.
Good morning.
Can you tell us your name?
My name is Robin Jane LaHood. Most people call me RJ.
Miss LaHood, have you been listening for the whole trial?
I have.
Then I want to give you a chance to respond right off the bat. Did you shoot Guy Gisborne with an arrow?
I did.
Why?
I believed it was the only way I could save Will Scarlett's life.
Did you shoot a second arrow at Mr. Scarlett that night?
No, that was my girlfriend, Marianne Mariansky.
Then I want to take a step back and focus on your background for a moment. Do you have a job?
I do. I'm the CEO of an athletic supply company here in Buffalo.
How'd you wind up doing that?
It's the family business. My father actually started the company, and sports were a huge part of my life growing up. I even competed in the Olympics for archery. So when my father passed, it made sense for me to take over.
And you mentioned that Miss Mariansky is your girlfriend. Were the two of you married?
No. I was married to Guy Gisborne. Marianne and we couldn't get married.
Why not?
My father never accepted me for who I am, that I'm lesbian. He told me the only way I could take over the family business was if I got married to a man.
Did you?
I did. I decided to fake it, to find a man and marry him. It was just to make my dad happy. And that man was Guy Gisborne. But Marianne and we stayed together the whole time.
Did you tell Mr. Gisborne about all that when you married him?
I did. Guy was gay and had his own boyfriend, Will Scarlett. So I offered him some of my inheritance in exchange for getting married. We agreed we'd each keep seeing our own real partners.
How much did you offer to pay Mr. Gisborne?
$1 million. I told him when my father died, I'd get 50 million in inheritance, and then we'd divorce and I'd give him $1 million.
And were you looking for ways to avoid paying Mr. Gisborne in August of 2020?
No, I always intended to pay Guy.
Then I'd like to move on and focus on August 6th, the night that Mr. Gisborne was killed. Where were you that night?
I was at my house. On the property, there's a main house and a guest house. I was on the main house that night.
Was anyone else around?
It was Marianne and I in the main house, and then Guy and Will in the guest house.
And you told us earlier that you believed Mr. Gisborne was going to kill Mr. Scarlett. Why did you think that?
Because of what my girlfriend, Marianne, told me.
What exactly did you think after talking with Miss Mariansky?
I thought Guy was going to kill William with peanut oil.
So how did you react?
I was shocked. All I could think of at that point was that I had to do something to save Will.
Well, did you try to warn Mr. Scarlett?
I couldn't. I started running after them, but it was too late. By the time I got into the road, they were already in the woods.
What about calling the police? Did you have time to do that?
No, I didn't think there was time. I thought Guy was about to kill Will. That's why they were going into the woods.
So what did you do?
I started running after them. And I thought I might need a weapon. So I grabbed my bow and arrow.
Did you catch up to them?
Kind of. I got into the woods, and in the distance, I saw that Red was on his knees in front of Guy.
So at that point, did you yell out to them?
No,
Why not?
that was when I saw Guy reach into his pocket and start to pull something out. I was just so scared that he was going to do something to kill Will.
So what did you do?
I shot him. It was the worst thing I've ever had to do.
What was going through your mind when you shot Mr. Gisborne?
That I had no other options. That I needed to save Will's life.
So after you shot Mr. Gisborne, what happened?
I turned around, but right after I turned around, I saw that Marianne was there too. And without saying anything, she shot another arrow.
Did you ask her why?
Yes, I asked her, and she said she dedicated her life to me and that she wanted me to give her something, to change my will so she'd get everything.
Then let's talk about what happened after Miss Mariansky fired that second arrow. Did you talk with the police?
Later that night, I did speak with Detective Figton.
And when you spoke with Detective Figton, did you tell him what happened?
No. I said I didn't know anything.
Why?
I just didn't know what to do. How to react to the fact I was being threatened. I was in shock about what was happening.
Well, did you ever tell the police what you just told us?
Of course. Several days later, I spoke with the police again and told them everything that happened. That I shot the arrow, but only to save Will. And that it was Marianne who shot the second arrow.
Thank you, Miss LaHood. No further questions at this time.
Very well, cross-examination.
Yes, Your Honor. Ms. LaHood, I'd like to start by talking about your relationship with Marianne Mariansky.
Okay,
You've known each other for quite a while now, haven't you?
pretty much our whole lives.
Right, you met when you were kids.
Yes, we did.
She followed you to college,
She went to a community college in the area. I went to college.
and she was your archery assistant in college too, right?
She was the assistant to our team, which ended up being my assistant as well, yes.
And you still live together now, right?
We do.
But you couldn't marry Marianne Mariansky while your father was alive, right?
Like I explained, he was very homophobic and said I had to marry a guy.
Right. He wanted you to marry a man or you wouldn't get your inheritance from him. Is that right?
Exactly.
So you struck up a deal with Guy Gisborne.
Yes, we agreed to a marriage of mutual convenience.
Right. You agreed that you would get married and he would get $1 million from you, right?
In the event of my dad's death and our divorce. Yes,
And this was laid out in a prenuptial agreement.
it was.
And that agreement said that he was supposed to get that money within a month of the divorce being finalized.
That is what the prenuptial agreement said. You're right.
And when your father passed away in November of 2019, well, you were able to finally get divorced from Mr. Gisborne, weren't you?
Yes, just a couple months later.
And that divorce was finalized in May of that same year, right?
The following year was November and then May of the following year.
Of 2020, right?
Exactly.
Ms. LaHood, I want to make something very clear for the members of the jury. You don't like Guy Gisborne very much, do you?
I mean, he's tried to murder someone, so no, I don't like him.
Well, even before he thought he was going to kill William Scarlett, you thought he was an insensitive prick, didn't you?
At one point, because he started trying to talk about money immediately after my father died. We've had many discussions after that, but in that moment, yes, I was feeling really sad about my father's death, and I thought the way he was treating me was insensitive.
That's a yes to my question, Ms. LaHood. You thought he was an insensitive prick, right?
At one point in time, I did.
But Guy Gisborne, he didn't like you very much either, did he?
Objection calls for speculation.
Your Honor, I'll withdraw the question. I'll lay the foundation.
Good idea.
Guy Gisborne tried to have you killed, didn't he?
I didn't know that until I heard Mr. Scarlett's testimony, but based on what I heard in court today, yes, he was part of a plot to kill me.
Right, Ms. LaHood, I'd like to walk through that plot to kill you. You had a break-in in your home in July of 2020, didn't you?
Yes, a man broke into my home that night while I was home alone.
Right, and you defended yourself by shooting that man in the stomach.
I did.
And you
With
shot
my
that man.
arrow.
You
Excuse me.
shot that man in the stomach intentionally, right?
Yes, to defend myself.
Right. You weren't trying to kill him. You're just trying to defend yourself, right?
I was trying to defend myself. You're right.
And after you shot him, you had the opportunity to ask him why he was in your home.
I tried to ask him before I called the police.
You did ask him, right?
Yes,
And you were in court today when William Scarlett testified.
I was.
You heard him say that he and Guy Gisborne hired that man to kill you because he hadn't paid Guy Gisborne his money yet, right?
I heard him say that, but that's not what the intruder told me that night.
I'm not asking you what the intruder said. I'm asking you what you heard in court today. Is that right?
I did hear Mr. Scarlett say something like that in court today. Yes.
And that's because at that point, you hadn't paid Guy Gisborne yet.
Well, I don't know if that's because I don't really know why they wanted to kill me, but you are correct that at that point, I had not paid Guy Gisborne.
And by the time of Guy Gisborne's death, you still hadn't paid him.
I didn't have a lot of cash on hand, and that's why we agreed he could live at my estate until I had enough money to pay him.
That's what I'd like to talk through why you didn't have any cash on hand. You said on your direct examination that you were going to receive $50 million from your father, right?
Yes, that was my understanding.
But you didn't have access to any of that money, did you?
Yes, there was some issue. The lawyers told me that I didn't have access to that cash yet at the time Mr. Gisborne had died.
The issue was that your father and his estate were being audited by the IRS.
Yes, exactly.
And you didn't have any access to the money in your father's company either, did you?
At that point, no, I didn't have access to all of the assets in the company.
And that's because that company was being investigated by the FBI for fraud, right?
That is my understanding. You're correct.
So all of that money was being held in a holding pattern, wasn't it?
Exactly. That's why I didn't have a lot of cash on hand, and that's why Guy was living on my property.
Now that Guy Gisborne is gone, we don't have to pay him that money, do you?
No, he's dead, ma'am.
I'd like to move on and talk about August 6, 2020. Marianne Mariansky came to you, told you she overheard a conversation between Guy Gisborne and someone on the phone, right?
Yes, she told me she heard Guy Gisborne speaking on the phone that day.
She said she overheard him say something about peanut oil, right?
That he had to get rid of Will and then something about peanut oil, exactly.
And then you saw William Scarlett and Guy Gisborne walking out into the woods.
Yes, I saw them far along on the path.
You saw them on the road before they went into the woods, right?
Yes, at the far end.
And at this point, before they entered the woods, you didn't yell out to them.
No, the road's about a half a mile and my voice isn't that strong, so I didn't think I would be able to.
Right. You didn't call the police when you saw them going in the woods, right?
Again, I didn't think there was time. I didn't think the police would arrive in time.
We're going to talk about the time you had, Miss LaHood, but you didn't call the police, right?
Right.
You didn't have Marianne Mariansky call the police while you went out and followed them in the woods, did you?
No, it was happening so fast.
You said the woods start about a half a mile from your house. Is that what you just said?
The road is about a half mile, I believe.
Okay. And then you followed the two men further about a half mile into the woods as well, right?
Well, at that point, they were already in the woods, but I started running and then I got to a clearing and I saw that they were already in the woods.
So you followed them for about a half a mile total. Is that right?
Well, at that point, they had already gotten into the woods, so I wasn't exactly following them. I saw that they were walking towards the woods. I
Miss
went to grab
Hood.
my bow and arrow, and then I ran on the road after them to try to find where they were in the woods. It wasn't like they were right in front of me and I was following them.
Miss LaHood, that's not my question. Yes, simple yes or no question. You followed them for about half a mile, right?
Again, it depends on what you mean by followed. They were in the woods by the time I got there, but I did go in the same direction of them just a short while later, if that's what you mean.
Okay, Miss LaHood, and all this time you were following them, you didn't call the police.
No,
Right.
Section, Your Honor, counsel's testifying. The witness was very explicit that she wouldn't consider what she was doing following them. So that for counsel to ask all this time while you were following them, it misstates the evidence and the testimony that's on the record.
It's cross-examination and it's the defendant. Overruled.
So in all this time you were following the two men, you didn't call the police, right?
again, I wasn't exactly following them, but you're right that I did not call the police.
Miss LaHood, you weren't following the two men, but you claim you ran after them to defend William Scarlett from Guy Gisborne?
Exactly. I saw them walking in the direction of the woods, and then a short while later, I ran in that direction with my bow and arrow.
And you just happened to run into the two men later in the woods, right?
Yes, there's one road in my woods. I went on that road, and that's when I saw them in the woods. I was at a clearing about 65 yards away.
Okay, I want to talk about what you saw when you're about 65 yards away from the two men.
Okay.
You saw William Scarlett kneeling down in front of Guy Gisborne, right?
Yes.
He was facing Guy Gisborne,
Yes,
and Guy Gisborne's back was to you.
it was.
At no point did you see a gun.
No, I didn't see any weapons.
You didn't see a knife.
Exactly. I didn't see any weapons.
You didn't even see any sign of peanut oil, did you?
No, I just saw him reaching into his pocket at the time I fired.
And you have no idea what he was reaching in his pocket for, do you?
Well, in court today, I heard that he had a condom laced with peanut
I'm
oil.
not asking what you know now. I'm asking at the time. You didn't know what he was reaching into his pocket for.
I had a pretty good idea it was something with peanut oil based on what Ms. Mariansky told me.
Miss LaHood, you
Was-
didn't see what he pulled out of his pocket, did you?
No, I was 65 yards away, ma'am.
So based on what you saw from 65 yards away, you felt it was necessary to shoot Guy Gisborne through the back, didn't you?
I did to save Will's life.
And you knew this shot would be fatal, right?
I knew it was a distinct possibility.
Now, after you shot Guy Gisborne, you went home.
First, Marianne Mariansky shot the second arrow. And
I'm
then
going to talk about Marianne Mariansky, but I want to talk about what
Your Honor, I asked the counsel allow my witness to finish her answer. She was giving a responsive answer and counsel cut her off.
Your Honor, that was not a responsive answer. I asked what she did, not what Marianne Mariansky did.
All right, everybody take a deep breath here. I don't think the interruption was intentional. I think I'm going to allow the attorney to restate the question, proceed to our next question, or restate the question. And it's difficult in this virtual environment to avoid interrupting witnesses. The attorney will be more careful. The witness will answer the questions directly. So, Ms. Conway, you may restate your question, proceed to your next question. That was a well-placed objection. And I take it Ms. Conway will restate her question or proceed to another question.
Yes, Your Honor. Focusing on your actions, Miss LaHood. After you shot this arrow, you went home, right?
Yes.
And you were home for about an hour.
Before the police came? Yes.
That's when the police arrived because someone had found your ex-husband's body in your woods.
Yes, Detective Ficton came.
And when the detective came, you told him you had no idea what happened.
I did.
You didn't tell him what you're telling us today, right?
No, I said I had no idea what happened.
You didn't tell him that you did what you had to do to save a life, did you?
I was in shock and I didn't tell him that. You're right.
So it was only 12 days later when the detective called you. You spoke to the police again, right?
Yes, that was the second time I spoke with the police.
The police told you they had found some DNA evidence.
They told me that, yes.
They told you that the DNA from your business card was found on the arrow in Guy Gisborne's body.
That is what Detective Ficton told me.
And after he told you that, you confessed to shooting that arrow.
Well, that's when I told him the whole story about what happened.
Right.
You're right.
After he confronted you with that evidence, you finally told him the truth, right?
Yes, that's when I told him the truth.
And that's because you had to explain why your DNA was on that arrow.
Yes.
And this is when you also told the detective that Marian Mariansky was the one that shot that second arrow.
Yes, I told him the whole truth about everything that happened.
And you're telling us that Marian Mariansky shot that arrow to frame you, her long-term girlfriend, for attempted murder, right?
I think she shot it so that I would give her more money in my will. And so then she would have to testify. I don't think she was planning to have me go to prison or anything like that.
Miss LaHood, you told us on direct that she shot that arrow to use as leverage against you, right?
Exactly.
And that leverage was that you would be framed for attempted murder because of that arrow, right?
If we didn't tell the truth, but that's why we are telling the truth today.
And
I'm going to admonish the witness, just answer the questions directly. Do you
Yes.
understand?
Yes.
Let's proceed.
was only the detective told you about the DNA evidence that you told the truth, right?
Yes, that is correct.
The detective told you there was no DNA found on that second arrow at the scene, right?
He said it was inconclusive, ma'am.
It was only after you heard that you told him the story about Marianne Mariansky, right?
That is when we told him the truth, ma'am.
No further questions.
Redirect, Your Honor.
Correct. I'm sorry,
Apologies. I was just asking if I can begin a redirect.
you may.
Thank you. Ms. LaHood, you were just asked about a plan to have you killed.
Mhm.
Did you know about that plan on August 6th of 2020?
No, I didn't know about it then.
On August 6th, before Miss Mariansky told you what she'd overheard, had you thought about hurting Mr. Gisborne before?
No, I hadn't.
Did you have any sort of grudge against Mr. Gisborne at that point?
At that point, no, I had no grudge. I was only trying to save Will.
Thank you. No further questions. May Miss LaHood be excused?
Any recross?
No, Your Honor.
Very well, she's excused.
Thank you.
Any further witnesses for the defense?
No, the defense rests our case in chief, and we would like to re-raise our Rule 29 motion on the same grounds.
It's denied. I don't want the prosecution to feel slighted, but I'll take it that their arguments in opposition to the Rule 29 motion would be the same as before. Correct?
That's correct, Your Honor.
All right. And what do you say we do now?
Defense is ready for closing arguments.
What about the prosecution?
Your Honor, we are ready to move straight into closing arguments, but I do have a motion to make on behalf of the prosecution.
Very well.
I think we've dipped a little bit under the 10-minute time that's remaining for our closing. Pursuant to the competition rules, we can move to ask Your Honor's permission to get a full 10 minutes for closing. I believe we might be at around 8 or 9 minutes, so we'd just be rounding up.
So you're saying you expect to have 8 minutes and you're going to ask for 2 additional minutes so that you have 10 minutes?
Yes, Your Honor.
That's granted.
Thank you.
Let's move it along.
Your Honor, I believe the standard practice, at least in the rounds that we've done so far, has been to allow for a brief recess to confer with counsel before closing arguments. May we ask for the court's indulgence for a couple minutes to do that?
Any objection?
No objection, Your Honor.
All right. Here's what we're going to do. We're going to take a 5-minute recess. Both parties will have the full amount of time to make their closings. And in that 5 minutes, they can maybe tighten up their closings a little bit. Just because they have 10 minutes doesn't mean that they need to take 10 minutes. That's up to them. But I want to commend you all for how well you've conducted yourselves. I'm very impressed. And what time do you have now, Ms. Conway?
My clock says 11:25.
11:26. We'll start up sharp and get right to it. Thank you. Time to refresh yourselves. No checking your Facebook or Instagram or anything like that, okay? Yeah. All right.
Your Honor, just to clarify, 5 minutes from 11:26, we'll come back.
Yes,
Okay,
5 minutes from 11:26.
thank you, Your Honor.
You bet. Bye. Bye for now. All right, if everybody's accounted for, let's strike up the band.
Yes,
I
Your
have
Honor.
to say that witness, that young woman who portrayed Mary Ann was captivating. But again, I don't judge the lawyers by their witnesses. She reminded me of a client who was in jail for shooting her boyfriend's wife named Mary Jo. Her nickname was the Long Island Lolita. Anyway, let's proceed with enthusiasm.
Yes, Your Honor. Good afternoon, members of the jury. I want to start by talking about something that you heard from the state in opening statements. You'll remember that Mr. Corey was on your screen and he was talking to you about what the evidence was going to show. And he said something that I thought was very interesting, so I made sure to write it down. Mr. Corey talked about tying up loose ends. Again and again and again, you heard about tying up loose ends. And I was thinking of Mr. Corey's words on the cross-examination of Detective Figton. You'll remember that he was the state's lead investigator, and he was on your screen and he was talking about what the investigation revealed and what it didn't reveal. He told you about how Miss LaHood told him that on August 6, 2020, she shot Guy Gisborne to save Red Scarlet's life. And you'll remember how Detective Figton told us that he didn't believe that story, how it wasn't supported by the evidence. And then we hear from Detective Figton on cross-examination. Mr. Warner's on your screen. He's asking questions, and we start to learn a lot of things. We learn that on August 6th of 2020, Mr. Gisborne is heard on a phone call talking about getting rid of Red Scarlet with peanut oil. We learn that Red Scarlet is deathly allergic to peanut oil. We learn that Mr. Gisborne is found with a peanut oil laced condom at the moment that he's killed. And we learn that a second woman has come forward and confessed to the state detectives about shooting the second arrow. So Mr. Warner says, well, detective, you had all that evidence. You knew all those facts. You had all those loose ends. Did you tie them up? Did you investigate them? Did you ask for that bow that Miss Mariansky used when she shot that second arrow? No. Did you ask for DNA samples? No. Fingerprints? No. Did you file a police report? No. No, 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 no. Members of the jury, think about what those words mean from someone who's in charge of a criminal investigation into murder and attempted murder. If you're in that position and you're a state detective, you don't get to say no. When you come across evidence, when you come across a confession showing that someone might be innocent, you don't get to say no. It's your job to investigate. It's your job to ask those questions. It's your job to tie up those loose ends. Because in a case like this, when the stakes are this high, when you have someone like Miss LaHood, whose life, whose liberty is on the line, you can't leave loose ends. But that's exactly what the state did. Because when it came to tying up loose ends, the state did not practice what they preached. That's why when they came to court today, they were not going to be able to give you the right answers to those two questions that matter most: the why and the who. Why did RJ LaHood shoot Guy Gisborne, and who shot the second arrow at Red Scarlet? Now, those questions matter because of what the state had to prove. As I expect Judge Murray is going to tell you before you go into that jury room, there are two elements that are in dispute in this trial. Mr. Warner is going to put them on your screen right now. For the first charge, the count one for attempt for substantive murder, the only element in dispute is whether or not Miss LaHood was legally justified in killing Mr. Gisborne. And the state had the burden of proof to prove beyond a reasonable doubt that Miss LaHood was not legally justified when she killed Mr. Gisborne. And for the second count, for count two, the state had to show that it was in fact Miss LaHood and not Miss Mariansky who fired the second arrow at Red Scarlet. This is what this case comes down to, and this is where the state fell short on these two elements and on those two questions. We're going to talk about one. Let's start with count one, the issue of justification. State didn't even come close to showing that Miss LaHood lacked justification when she shot Guy Gisborne. If anything, the evidence shows the opposite. You heard how Marianne Mariansky overheard that phone call in which Guy Gisborne talked about getting rid of Red Scarlet with peanut oil. You heard how Red Scarlet was deathly allergic to peanut oil. We all agree that every single person on the property that day knew about that allergy. Red Scarlet told you that on cross-examination. And you heard how Miss Mariansky told Miss LaHood about what she overheard. And you knew that Miss LaHood acted in defense of Red Scarlet when she shot that arrow, based on the information that she had, based on her trust in Miss Mariansky. That's justification. And that's why the state fell short. Let's talk about count two, the issue of attempted murder. Here we have a straightforward question of identification. And this one is pretty easy because you had someone get on your screen today and say under oath that it was her and not Miss LaHood who fired the second arrow. It does not get any clearer than that. Now we get it. Miss Mariansky is not a model citizen. She tried to lie, she tried to blackmail, she tried to extort Miss LaHood after being her partner for 10 years. She admitted to all of that. She even destroyed evidence. And we're not asking you to like Miss Mariansky, but we are asking you to believe her. Because when you scrutinize her testimony, you'll see that it's corroborated by all of the other evidence in this case. Miss Mariansky told you about hearing about peanut oil. You heard how the state had to even admit that peanut oil was found on the condom in Guy Gisborne's hand. You heard Miss Mariansky talk about shooting the second arrow, but not the first one. And you heard how Miss LaHood's DNA is on the first arrow, but not on the second. You heard how her fingerprints were on the first arrow, but not on the second. You heard how the first arrow hit its target. The second one missed it. All of that is corroboration. And all of that is why you can and should believe Miss Mariansky when she told you that it was her and not Miss LaHood who shot that second arrow. That's what happened to you. Those are the answers to those two questions that matter most. Why did RJ LaHood shoot Guy Gisborne? To save Red Scarlet's life. And who shot the second arrow? It wasn't RJ LaHood. So we've talked about the facts. Let's talk about the law. Mr. Warner, can you put on the screen right now the first count instructions for justification? In a few moments when you go into that jury room, Judge Murray is going to give you some forms and you're going to be asked to fill them out. And some of the language on the instructions, it might seem a little complicated, but it's really not. We're going to work through it right now. For the issue of justification for count one, what you have to ask yourself, the law says, is whether or not the defendant actually believed that there was a threat of deadly force against an innocent person, and whether or not a reasonable person in those circumstances would have believed the same thing. So for the first question, of course, Miss LaHood actually believed that Guy Gisborne was going to use deadly force against William Scarlet. You heard all of the reasons why she believed that. Miss Mariansky told her there was about to be a murder if she didn't stop it. And on the second question, would a reasonable person in her position have believed the same thing? Of course, any reasonable person in that position would have believed what Miss LaHood believed. Any reasonable person who has their partner of 10 years run up to them and tell them that there's about to be a murder is going to believe their partner of 10 years. So your answer on count one is going to be not guilty. Miss LaHood had justification. And that brings us to count two, identification. Who shot the second arrow? And here it's even easier. You can't be guilty of attempted murder if someone else attempted the murder. Miss Mariansky admitted that she shot the second arrow And that's all there is to it. Your answer on count 2 is going to be not guilty. Let me say one last thing, members of the jury, about reasonable doubt before I sit down. And can I ask Ms. LaHood to please turn on her video briefly? Members of the jury, you should understand that proof beyond a reasonable doubt, the burden that the state had, it's the highest standard in the American legal system. And the reason that the standard is this high is because the stakes are this high. We believe that there are times when the police are going to make mistakes, and we believe that there are going to be times when innocent people like Ms. LaHood get charged for things they did not do. This is one of those times. And that's why we're confident that when you come back from that jury room, you're going to come back with the only verdict that the facts support, the only verdict that justice demands, and the only verdict that the woman on your screen deserves. She's not guilty. Thank you.
Very well. Who will give the closing for the prosecution?
I will, Your Honor.
You may proceed.
Yes, Your Honor. Your Honor, opposing counsel, members of the jury. The defendant was tying off loose ends. Today, you've heard a complicated and convoluted story about 4 people. 4 people brought together by a sham marriage for financial gain. The defendant, Robin LaHood, recruited her victim, Guy Gisborne, to marry her so that she could receive her father's inheritance. But the defendant was already in a relationship with Marianne Mariansky. And as a matter of fact, Guy Gisborne was already in a relationship with William Scarlett. And somehow, through some twist of fate, it happened to be that William Scarlett was the brother of Marianne Mariansky. This complicated set of relationships boils down to one very important fact. Guy Gisborne is dead, and the defendant is the one who killed him. Now, the state has charged the defendant with 2 charges: murder in the 2nd degree of Guy Gisborne and the attempted murder of William Scarlett. This means that we had to prove to you today that the defendant intended to kill Guy Gisborne, actually did so, and was not justified in killing him. We also had to prove to you that the defendant intended to kill William Scarlett and attempted to do so. And we needed to prove those elements to you beyond a reasonable doubt. And we have met that burden today, members of the jury, because we know it was the defendant who shot both of those arrows. We know the defendant and Marianne Mariansky have created a story to match the DNA evidence the police had against them. We know that the defendant was tying off loose ends. Now, a question that defense counsel has been asking you to consider today is the why. Why would the defendant do this? We told you why. We gave you 2 reasons why the defendant would want both of these men dead: money and revenge. You heard from William Scarlett today. He took the stand and he told you about the deal struck between the defendant and Guy Gisborne, which Guy Gisborne would marry the defendant and receive $1 million within a month of that divorce being finalized. But when the defendant refused to pay Guy Gisborne, well, he got angry. And he and William Scarlett hired a hitman, Tucker Frierson, to break into her home and kill her. The defendant told you today she had no idea it was these 2 men who hired Tucker Frierson. But you heard that she had an opportunity to ask Frierson who sent him. And you heard from William Scarlett that Frierson admitted he told the defendant exactly who sent him. The defendant knew that it was William Scarlett and Guy Gisborne, and she wanted revenge. You've also heard that the defendant owed Guy Gisborne quite a bit of money. Guy Gisborne was supposed to get $1 million from the defendant. But you heard from the defendant herself today, she couldn't pay that money. She didn't have it. She didn't have access to the $50 million from her father's estate because he was being audited by the IRS. She didn't have access to any of the money from her company because it was being investigated by the FBI. The defendant needed that $1 million. And she had 1 million reasons to get rid of Guy Gisborne. Now, clearly the defendant had multiple motives to do both of these things. But the defense has come up with a different story to try to explain why the defendant killed Guy Gisborne and scapegoat away who shot that second arrow. I'd like to talk about that story with you right now. The defendant claims that she shot Guy Gisborne to save William Scarlett's life. She says that Marianne Mariansky came to her, panicked, saying she overheard a conversation in which Guy Gisborne said he was going to kill William Scarlett. Members of the jury, that's not what we heard today. We heard two vague statements about peanut oil. We heard no explanation of those statements. We didn't know the context of those statements. No one else heard these statements but Marianne Mariansky. And she doesn't even know who Guy Gisborne was talking to. And we're supposed to believe that this was enough to make the defendant believe that immediate and fatal action had to be taken to save William Scarlett's life. The defendant told you that after she heard this from Marianne, she saw William Scarlett and Guy Gisborne go out in the woods. She says that she immediately went and got her bow and arrow and ran out in the woods after them. And the defendant fought me a lot today on whether or not she was actually following those men. But what we know is the defendant claims that she ran out after them to save William Scarlett's life. And eventually she caught up to them. She was 65 yards away. She didn't call out once. She didn't yell at them to stop. She didn't tell Guy Gisborne, hey, I see you, don't do this. She claims she had no other option but to put a bow in her arrow and shoot him. But you heard her admit today, she didn't see a weapon. She didn't see what Guy Gisborne was pulling out of his pocket. She knows now it was a condom, but she didn't know that then. She had no idea. She just shot Guy Gisborne through the heart. After the defendant shot Guy Gisborne, she went home and she did nothing. She didn't call the police and tell them what she's telling us today. She didn't tell them she did what she had to do to save a life. Actually, she actively lied to the police. She told them she had no idea who had died or how Guy Gisborne had died. It was only 12 days later when the police confronted the defendant with DNA evidence that she told the truth. She admitted to shooting the arrow that killed Guy Gisborne because the detective told her they had her DNA on that arrow. She told the detective that it was Marianne Mariansky who shot that second arrow because there was no DNA evidence against the defendant on that arrow. Marianne Mariansky told us today that she shot that second arrow to use as leverage against the defendant. And Mr. Barile said something interesting on his closing argument that I want to really highlight for you, members of the jury. He said the defense isn't asking you to like Marianne Mariansky. He pointed out that Marianne Mariansky lied to the police. She's blackmailing her long-term girlfriend, and she destroyed evidence and hid that evidence from the police. But then he asked you to trust the word of Marianne Mariansky, despite all of these things. We are supposed to believe someone who actively obstructed this investigation when they say they are blackmailing their long-term girlfriend, and they are the ones that shot that second arrow. Ask yourselves, members of the jury, does this story make any sense? It doesn't, because they're making it up. And we know they're making it up because you heard from Detective Figton. He told you that Marianne Mariansky could not have shot that second arrow. We know that arrow was shot by this bow, which required 50 pounds worth of draw weight to make an arrow fly. And that shot was shot from 110 yards away, where it only missed William Scarlett because he fell at the last minute. And you heard from William Scarlett that Marianne Mariansky isn't a skilled archer. She couldn't hit the broadside of a barn. And we're supposed to believe that she narrowly missed her target shooting 110 yards away through branches and bushes and trees? Defense has been asking you who. We know who. We know it was only the defendant who could have made this shot. The Olympic archer. It had to be Robin LaHood. The defendant eliminated her need to pay Guy Gisborne the $1 million by killing him. She enacted revenge for the attempt on her life by killing Guy Gisborne and trying to kill William Scarlett. And now she's tying up loose ends by making up a story that fits the evidence against her. We ask that you not be fooled by this story. We ask that you remember that most often, the simplest explanation is the correct one. We ask you to find the defendant guilty on both counts. Thank you.
Very well. What do you say we do next? I need to fill out a evaluation, as do the evaluators. I also will have a chance to make some comments that I'll try to keep brief and constructive. My question is whether I should direct my attention to filling out the sheet right now and then make my comments, or make my comments first.
I think that's a question for the bailiff if they're on the
Yes.
call.
What do you say, bailiff?
I'm not sure. This
All
is-
right. Well, I'm going to make a command decision here and fill out my form, providing that everybody else stays available. I'll keep my comments brief. I won't tell you what I thought you did so well. I'll tell you what I thought you could do better. So I'm going to take myself off the screen, complete the form, and then come back. Any objection to that? Hearing no objection, that's exactly what I'll do.
All right, I guess while our judge is submitting his score sheet, this is John Menard. I'm one of the evaluators. I did submit my score sheet. I presided over one of the earlier rounds, so I'm probably far too familiar with the fact pattern, and I think the prosecution is certainly at a evidentiary disadvantage when it comes to the case. Just a couple of observations that jumped off the page for me. The first thing that was brought up was I guess the identification of the DNA. I think the only thing I would suggest maybe going into the final, because obviously one of your teams is going to the final, is just to double check and see if the stipulation kind of precludes an argument that the DNA from the business card is actually identified as Ms. Hood. I think the implication is that it is. It's a fantastic argument. I love that argument, but that'd probably be something that would have been, I don't want to say rectified, but it probably would have been argued in motions before you got to trial. So, or Ms. LaHood would have been retested to confirm the results of the DNA on the arrow. But I would just double check that, just so you don't run into an issue in terms of obviously the rules. And then the other thing was, in terms of the trial order of dismissal, in my case, I reserved on that, and then I granted it at the end of the trial because I didn't think there was any sufficient evidence to sustain the attempted murder. From my perspective, another witness or another person saying that they committed the crime is probably reasonable doubt. So from that perspective, I think that's the only, I guess, conclusory difference I would have made on the case. Overall, everybody was excellent. In terms of openings and closings. Nobody overcommitted and underdelivered. That did happen at the other one, where a lot of here's what you're going to hear, and then that actually didn't come out in the evidence. In this case, everybody was pretty sensitive to making sure that the important points they made in their openings and closings obviously vetted out during the witness testimony. The only other thing I think I'm going to add in is in terms of witness preparation. I think everybody did an excellent job of that. I do a lot of trials, and witness preparation is a nightmare. And having witnesses that you can actually count on to stick with their stories, even if they don't have a script and they lived it, is a very difficult thing. So all of you have to be commended for for making sure that your witnesses didn't fill in things that would be problematic, but also provided the testimony I think that that the project calls for. So that was excellent. Yep, I think that's it. So I don't know if evaluator Kent has any thoughts, but I guess we'll just wait for the judge to come back and we'll go from there.
Thank you
I'm
very much.
almost finished with my score sheet, and then I'll make my comments. Hi, folks. I think you can hear me.
We can, yes.
My name is Liz Kent, and I'm an evaluator here in Buffalo. Boy, I was really impressed. You guys were very, very well prepared. It's unfortunate that there can only be one winner. I would caution you about my only comment, really, other than being very complimentary, is please be careful with moving from the present tense to the past tense. I find that personally very irritating. It may be a function of the prevalence of social media and how people communicate there. In other words, I'm dating myself. The plaintiff's opening was very succinct, and I really appreciated that. You guys were all excellent, very excellent. I'm really, really impressed. Thank you for letting me participate, and thank you for giving me this opportunity to listen to you. I'm sure you'll all do very well in the future. Congratulations.
Thank you.
Thank you.
Thank you.
Bailiff, it looks like Judge Murray might have left the Zoom meeting. Are you in contact with the judge, or do you know?
I do. Let me check on him and I'll get right back to you.
Yeah, no, there's no rush and there's no need to. I just wanted to make sure that there hasn't suddenly been a power outage or something.
No, I did notice he left. I was hoping he was just going to pop back up, but give me a second.
Okay, sure. Yeah, thank you.
Hi, everyone. Please go into when you're done, if you still have anything to do, please go to the award ceremony room for the announcement. It'll be a few minutes, so just whenever you get a chance.
Okay, thank you.
Yep.
Hey, really great round again. This was like really a lot of fun. Like very earnestly and sincerely, thank you guys for a great semifinal.
I think we definitely agree. This is a fantastic round. And if you guys end up advancing, best of luck. Like, we are rooting for you guys 100%.
Yeah,
Likewise. Good luck.
1000%.
Good luck either way. And yeah, maybe we'll see you guys around the other tournaments this year.
I hope so. Bye.
All right.
All right. See you guys. Good luck.